All right, we are live streaming.
Okay, great. Well, so good morning to both of you. Thank you for participating in your oral argument today via Zoom. We understand, the panel understands it's a challenge. And so I want to assure you that we're going to be patient with you if there's any technological difficulties. And I hope you're patient with us as well. Before I introduce the panel, I would just like to say a couple of things. First and foremost, we hope that your families are well, that you're feeling well, and everybody is safe and healthy. Second, we'd like to thank the appeals court team for developing and implementing this platform, which has enabled us to go ahead and hear cases and forge ahead, if you will, despite these trying and challenging times. I'd also like to say now that the arguments will be conducted just as if we were in the courtroom. The same rules of appellate procedure apply. Each side has 15 minutes to make their argument. As always, you can be assured that we've read everything that you have submitted to us and that we know the record well. I think you both know, since I'm familiar with both of you, that there's no rebuttal in the appeals court. And with that said, and you can see the names, but let me just introduce my panel: Justice James Milkey, Justice Kenneth Desmond. My name is Ariane Vuono. And again, we can start the clock right now.
Right.
Okay. The first case we're going to call is Commonwealth versus David VENETUCCI, 2019-0208.
Good morning. May it please the court. My name is John Day. I'm here on behalf of the appellant, David VENETUCCI. The issue to be addressed with this particular appeal is whether Chapter 123A, which the courts have established consistently over the last 20 years, is a non-punitive remedial statute, authorizes the Commonwealth to commence an SDP civil commitment petition against a person like Mr. VENETUCCI, who still has a nearly 6-year federal consecutive prison sentence to serve. More specifically, he's been sentenced to 71 months, or 5 years, 11 months, out of the United States District Court for here in Massachusetts to serve a sentence. And that sentence explicitly says, unambiguously says, that the federal sentence is to be served consecutive to any Massachusetts state sentence. So Mr. VENETUCCI completed his Massachusetts state sentence in 2016. The Commonwealth timely filed a petition for civil commitment about a month before his state sentence ended. But at all operative times during the course of that proceeding, Mr. VENETUCCI has objected and preserved his rights to argue that the Commonwealth should not be pursuing a civil commitment petition now, because he has at least 5 years, actually 71 months, of a federal sentence to serve before he can be released into the community.
Counsel, can I ask a question? You and your brother both appear to assume that he cannot begin serving the federal sentence until he's released from SDP confinement. Is that necessarily correct, given that the federal sentence is supposed to be served on and after the state sentence, which is now concluded?
My understanding, Your Honor, is that typically the federal statute says that if you're being held in custody, you can be credited for that custody. The problem here is that the federal judge who imposed the sentence explicitly said that the sentence was to be served at the end or consecutive to any Massachusetts state sentence.
But
So,
that sentence is, excuse me for interrupting, but as Justice Milkey pointed out, that sentence has now been served.
that sentence has been served, but he's not in U.S. Marshals or Bureau of Prisons custody. And at the end of the day, if my research is that the Bureau of Prisons is the ones who determines what sort of jail credits are given, both in terms of any sort of good behavior type reduction of sentence. He's allowed up to 54 days a year.
Let me interrupt for a second, because even before we get there, there's currently a detainer from the Bureau of Prisons that would have been lodged while your client was still in serving his state sentence. So why isn't the BOP picking him up? He's no longer serving a state sentence. He's now in a civil, there's a difference between being civilly confined, of course, obviously, and serving a state sentence.
And I don't, please, I'm not trying to be overly technical here, but just so the record's clear, it's actually a U.S. Marshal's sentence, or excuse me, a detainer. And so he's not officially in Bureau of Prisons custody yet, but the Marshals did file the detainer to take him into custody. And my understanding, and I think my brother may be able to speak to this because he's maybe more aware of what happened, but that detainer was served on the Department of Correction at the Massachusetts Treatment Center. It was signed by the administrator of records there, a woman named Donna Swanson, but the Commonwealth has refused to honor the detainer on the grounds that this Chapter 123A petition is controlling over the federal detainer for the federal sentence.
Okay.
Attorney Day, let me ask you this question, if I may. If a remedial statute has a collateral penal effect, is it your position that it's prohibited?
It is. Yes, it is, Your Honor. And I would suggest this is a collateral penal effect because what this is doing is essentially is for no good reason. I would suggest this, that the 123A, I think we all agree that the legislative intent behind that as interpreted by the courts has been to protect the community from someone who at the time of release in the community suffers from a mental condition that renders him potentially dangerous. In this particular context, we don't know what Mr. VENETUCCI's mental condition will be when he is released from the federal sentence. And that actually, this court addressed that specifically in the Shedlock matter, where the individual still had 2 years to serve on the remaining consecutive sentence, a state sentence, before the government should have filed the petition. And this court noted that the government cannot, in good conscience, file a petition that much earlier before the end of the sentence because there's no telling what the person's mental status will be at the end of the sentence. So that's a long answer, Your Honor, and forgive me, but yes, my position is that as applied in this particular case, Chapter 123 is improperly punitive because it's depriving Mr. VENETUCCI for no good public interest reasons of the ability to begin serving his federal prison sentence and complete that. Essentially, I'm concerned it's going to be considered dead time.
At the same time, when you indicate that the Commonwealth, I believe you use the term colloquially, in good conscience, could not file a petition prematurely. In other words, potentially 6 years before Mr. VENETUCCI would actually be in the community. On the other hand, that's what the legislation calls for. The Commonwealth will not be able to file this petition later. The Commonwealth is supposed to file this petition upon within a certain amount of time of the completion of the state sentence. So is this problem really one for the legislature, not us?
I think it probably is. I think there is an ambiguity here. And in fact, if we look at that Washington state case that both the Commonwealth and I addressed in our brief, because the trial judge had referenced it, there was no ambiguity there because a Massachusetts statute defines a sentence of imprisonment as a Washington state term of imprisonment. We have an ambiguity here. And I do think it's probably something the legislature should resolve. But in the meantime, given the fact that Mr. VENETUCCI's liberty interests are at stake and it's a civil remedial statute, I think that ambiguity respectfully must be interpreted in his favor. And this petition the Commonwealth's petition should be vacated and he should be sent off to serve his federal sentence.
Counsel, to be clear, what specifically are you saying the ambiguity in the state statute is?
Whether or not when the language says that the petition is to be filed at the end of the respondent's sentence, whether that criminal sentence is just for a criminal sentence here in Massachusetts, or if it includes any other federal or state, any other jurisdictional prison sentence the person still has to serve. And I suggest that that's a core ambiguity because, again, the case law with regard to Chapter 123 is clear that the petition should not be implemented until the person is about to be released into the community and potentially poses a risk to the community. So I think the ambiguity is whether or not a petition can be filed when a person still has a nearly 6-year federal consecutive prison sentence to serve.
So just a follow-up question, are you saying that because of that ambiguity, the statute could be interpreted as allowing the Commonwealth to file an STP petition directly before he was released from federal custody at the end of his federal sentence?
I think that that ambiguity would cut both. Yes, I do think that that's potentially an issue as well. I would suggest that the ambiguity says at this particular time, the Commonwealth does not have grounds to file a petition or jurisdictional authority to file a petition, but given the fact that he began his imprisonment in a Massachusetts custody, and frankly, I would suggest that the government may try to take some, I don't want to get into the, I would not be surprised if he were to be transferred to federal custody at this time, eventually Bureau of Prisons custody, if the state of Massachusetts may not try some sort of legal process to put something in place. So at the end of his sentence, he can be brought back.
Now, you said twice in this argument that the Commonwealth cannot file a petition. Is it the filing of the petition that is the problem, or is it the finalization of the petition? And as you're thinking about that, you put a lot of reliance on the 2015 Sorb case. In that case, the SJC seems to have said that you can't finalize the classification. In other words, you have to keep the record open to get all the information that occurred in the intervening years, but it doesn't say you can't start the process. Is there a problem with the Commonwealth starting the petition process and then staying it while he serves his federal sentence?
I would suggest yes, there is, and the reason is that again, within the realm of Chapter 123A proceedings, the law is clear that the government or the Commonwealth cannot file the petition until it has a good faith basis for saying that the person at the time of release possesses some sort of a mental condition that renders him dangerous. And again, and respectfully, I suggest this court in the Shedlock decision followed up on that and said at that time that the government, the Commonwealth would have a difficult time in good faith filing a petition 2 years before his remaining state sentence expired. So in this particular case, or in a Chapter 123A proceeding, because the petition can't even be filed without a requisite finding, at least from a record review by a doctor, per Bruno, a psychologist, that the person is at that particular time suffering from a mental abnormality or personality disorder, I would suggest that it's impossible now for the Commonwealth to file a petition knowing that the issue is going to become what his mental condition is when he finishes this lengthy federal prison sentence.
But now, go ahead, Jim.
If he were released to federal custody now and began serving his federal sentence, would there be any problem from your client's perspective? Were the feds toward the end of his sentence to send him back to serve the rest of his federal sentence in state custody, where the state could, if it chose, file an SDP petition at that time?
If that were possible, I mean, I'm not sure that he could be transferred back into state custody, and I just don't know if there's a mechanism to put him back in Department of Corrections criminal custody if he's finished his state prison sentence and he's if it was a concurrent sentence, I think that would be a possible scenario here. But the problem is the state prison sentence is completely fulfilled and the federal prison sentence is consecutive to it. So there's really no basis for transferring him back into Massachusetts custody on a criminal sentence.
So how would the Commonwealth ensure that they were being true to the statute? If we were to release him to serve his federal sentence and the Bureau of Prisons decided that he was going to be off to New Mexico, I mean, it's up to them to determine where they're going to house him. And then as he approaches his end, how does the Commonwealth come in to do an assessment to determine what his status is by way of sexual offense at that time?
Respectfully, Your Honor, they may not be able to. But again, there's a competing, as the court's well aware, there's a competing set of interests here. And in this particular case, I think this might be a position where given the ambiguity in the statute, given the fact that we don't know what his status is going to be when he finishes this almost 6-year federal sentence, it may very well be that in this particular case, pending any remedial work by the legislature or changing of the statute by the legislature, in this particular case, we may have to rule that Mr. Venetucci's liberty interest and his due process rights are more important than the government's interest in seeing whether or not almost 6 years from now he has a mental condition that may render him sexually dangerous. It may just be one of those cases.
Your brother might say that there is no ambiguity because the statute doesn't say all sentences, including federal sentences. You're reading into that in ambiguity. So perhaps the burden should be on you to pursue that.
Your Honor, I would respectfully respond to the Commonwealth's argument in that regard by saying that the jurisprudence is absolutely clear that in these particular proceedings, because they are a derogation of liberty, that the statute must be strictly construed. And to the extent that there is an ambiguity, that ambiguity must be construed against the government, given Mr. Venetucci's due process rights to liberty.
I hear you, but I'm not sure which way that cuts, because you seem to acknowledge earlier that the statute can be interpreted as deferring the STP question till the end of the federal sentence. And if that's true, is that a better due process result for your client?
I think it is, because at least then we'll know we'll have a better idea as to what his potential mental status is at that particular time. Right now, we have no way of gauging what his mental status is going to be nearly 6 years from now.
Then we're back, of course, to the question that's been asked before, which is how does the Commonwealth keep track and be able to file that petition at that point in time?
I recognize that's
mechanism for that. And as Justice Desmond points out, this individual, your client, could be anywhere in the United States serving that sentence.
Your Honor, I can't dispute you. I can't argue against that. But again, I think that when we weigh the interest of the individual's rights versus the Commonwealth's in this particular case, given the jurisprudence for Chapter 123, that Mr. Venetucci's rights should govern this proceeding.
Isn't the real response to that the feds could file their own SDP petition under the parallel federal statute, especially if he were, for example, serving in New Mexico?
They can, Your Honor. I purposely stayed away from that because I thought it was unduly speculative, but they do have their federal civil commitment process as well, which does apply in this case. In other words, Mr. Venetucci's criminal history would qualify him for federal SDP commitment. I think they call it sexual violent predator commitment. If the federal government were to pursue that at the end of his federal sentence, yes.
Which of course would impose a cost on them that they might argue should be borne by the Commonwealth.
Again, that could be a sovereign to sovereign argument, Your Honor, but I think that Mr. Venetucci's individual rights at this particular point in time shouldn't be subject to that budgetary dispute between those two sovereigns.
And would you also say, I see your time's expired, but just to follow up, then would you also say that that the feds, or could one say that the feds have an interest in that regard, because Mr. Venetucci could be anywhere and the Commonwealth would no longer have the same interest in protecting the Commonwealth, the community of the Commonwealth, because Mr. Venetucci is no longer residing here, assuming, of course, that he serves his term of federal custody elsewhere.
I would agree with that, Your Honor. And again, he also has a 240-month federal supervised release or probation sentence he has to serve as well. So they do have an interest in pursuing him or monitoring him also.
Okay, I'm going to see if the panel has any more questions. I'm sorry, just Judge Desmond.
That's right. So one final thought. Again, the Commonwealth would certainly be, I'll say, at the mercy of the federal authorities, because should he finish his sentence wherever he may serve it at federal sentence, and then comes right back to Massachusetts, Massachusetts is left kind of with no recourse.
Well, he'll have the 20 years of federal supervised release hanging over his head, and of course, if he commits any crime, he can be petitioned by the government, by Commonwealth again, if he's in Commonwealth custody.
So they'd be at the mercy, arguably, of the federal probation supervision or federal parole supervision.
Well, Your Honor, I would quibble with the words "at their mercy," but I would suggest
That might not be the best words I can see.
but I understand the court's position. I understand the court's statement. Again, though, Mr. VENETUCCI could be found himself being committed back in Massachusetts if he were to commit a crime in Massachusetts, and of course were to be placed in custody. This could all begin again at that point.
I actually have another question. Thank you for your patience, everybody. And that is, is it safe for this panel to assume that this issue was not addressed when Mr. VENETUCCI was sentenced in federal court?
Yes, Your Honor. I've spoken to his federal defense attorney, and this was not something that came up during the federal sentencing at all.
Okay, and it was before the former district attorney, United States District Court Judge Mark Mastriani, right? Was that
It was,
the judge
Your
then? Okay.
Yes,
all
Your
right.
Honor.
I'm going to ask the panel has any more questions before we move on.
No questions.
No? No. Thank you very much. Okay.
Thank you.
Attorney Lynch?
Morning. May it please the court, Travis Lynch for the Commonwealth. The existence of the defendant's federal sentence has no effect on the Commonwealth's ability to file Chapter 123A petition. And I think Gardner makes pretty clear that if the Commonwealth waited for the defendant to finish his sentence, it couldn't petition at that time. I think Gardner limits a 123A petition to situations where the defendant is serving a Massachusetts sentence in Massachusetts. I think it, so if we did what the defendant suggested and waited until he was finished with his federal sentence, the Commonwealth would not be able to file a petition under Gardner. And there's nothing in the statute that suggests that the Commonwealth has to wait for the defendant's sentence in the federal system to be completed.
So what do you say about the fact that there does seem to be this looming issue, which is that Mr. VENETUCCI could spend a considerable amount of time civilly committed and have looming over his head an additional 6 years in federal prison to be followed by 240 months of supervised release?
I don't see what the due process concern is with the defendant having, I mean, he committed more crimes against another sovereign. I don't see what the due process concern is. I mean, reading the statute the way the defendant suggests would encourage people to commit crimes in other jurisdictions just so that they can avoid an SDP commitment.
Mr. Lynch, how about this as a due process concern? Let's say we knew through a crystal ball that in 6 years he would age out of being an SDP. Under the current scenario, he has 6 years in civil confinement as an SDP. Then he gets released from that because he's no longer an SDP because of his age. Then he has 6 more years of confinement in federal prison, while if he did the federal prison first, he'd be done in 6 years. Doesn't 6 years of someone's life count as a due process problem?
Assuming that we knew in the future that he would no longer be an SDP, but that's not, we can't know that. I mean, no, I would say not. I mean, the hypothetical assumes something that we can't possibly know, that he will stop being dangerous in the future.
But isn't that the point, that we can't possibly know it now? We don't know his mental condition 6 years from now, when at a minimum he would be able to go back into the community. And doesn't Shedlock fairly dramatically say that would be a problem?
I would point out that Shedlock was under the 1999 version of the statute, not the current version. And also I would point out that in Shedlock, the issue in Shedlock was that the defendant had consecutive Massachusetts sentences. So the first sentence was the qualifying conviction, and then the second sentence was a non-qualifying conviction that was to be served consecutively. And the defendant attempted to argue that the Commonwealth should have petitioned at the end of the qualifying sentence but the Commonwealth waited until the end of the complete sentence. But the point is, he was in Massachusetts custody the whole time. So, so I don't think that the concern in Shedlock is really present here. I mean,
Well, how do you address the 2015 Sorb case that your brother cites in your brief and you don't discuss in your brief, where the court said that there is a due process problem with classifying someone, finalizing a classification as a level 3 2 years before someone is due to be released? If there's a due process problem with Sorb classification, why isn't there ipso facto a due process problem with classifying someone as an SDP 6 years before he could go back into the community?
Well, one thing that I point out, that's DOE 7083. In that case, the defendant, I guess he would be the plaintiff in that case, he had been in the treatment center for 32 months already. There was evidence in that case that number 7083 had been making progress on his sex offender treatment while he was in custody, while he was at the treatment center. And the other thing about that case is that the reclassification procedures didn't fix the problem, because he would have to wait 3 years after the classification to show that he was getting better. And during that time, he had no chance to show that he could live in the community. In this case, there's really no question that right now, when the defendant was set to be released from Massachusetts custody, he is an SDP. That there's no dispute about that. He is an SDP, or there was probable cause to believe he was an SDP when we started this proceeding. The judge found beyond reasonable doubt at the time of the trial, which was 2 years ago, I believe, that he was an SDP right then. He's an SDP now. The question isn't whether he'll be an SDP later when he's done with the federal sentence. The federal sentence doesn't have any interaction with what's going on here in Massachusetts. The federal government has, from what appears in the record, they haven't attempted to get involved with Mr. VENETUCCI's case in Massachusetts, other than lodging the detainer. That's my understanding, and that's what's in the record. And again, I'd point to the Trapaga case. The defendant remains subject to the laws of Massachusetts while he remains a prisoner of Massachusetts. He's still subject to our SDP law.
What else could the feds do beyond lodge the detainer?
I'm not exactly sure what they could do
Well, isn't there a tension between the federal criminal sentence and the state civil action? And don't the feds have an interest in having this defendant serve federal time for a federal offense?
They may, but they haven't done anything to make him serve the sentence other than lodge the detainer. They haven't, there's nothing in the record that indicates that they've attempted to do anything in these proceedings. So
What more can they do?
I'm not sure, but but he still belongs to Massachusetts. That's the point.
Well, is Massachusetts doing anything to prevent the marshals from picking him up and delivering him to wherever they do the intake now, Fort Devens or wherever they do it now?
Not that I'm aware of, and I don't think there's anything in the record that indicates that Massachusetts is preventing the federal government from doing anything.
But for all we know now, the federal government may be just as happy to have him locked up in state SDP custody, correct?
That's possible. I mean, he might be earning credit against his federal sentence while he's in SDP proceedings. I'm not entirely sure about that, but
Okay.
I mean, so that might be happening. But
Is there any problem from the Commonwealth's perspective with the option of him serving his federal sentence now and then being released back into state custody to serve the remainder of his federal sentence as it's about to expire? Assuming you could do that, is there any problem with?
Well, you can't do it.
I don't think you can do, well, thank you. I think Gardner says you can't, I think Gardner says you can't do that. Because in Gardner, the defendant was serving, I mean, granted, Gardner is a case about a Rhode Island sentence that he was actually serving in a Massachusetts correctional facility. But I don't think you could do that under Gardner. So,
And if you could, wouldn't he then be subject to federal rules of incarceration while housed in a state system? And so the state would have to perhaps adjust how they treated this defendant.
that's possible.
And there would be no problem, I take it, for the feds to file their own equivalent of an SDP petition at the end of their federal sentence.
Not that I'm aware of, but I mean, the federal government might be happy to leave this to Massachusetts, but I think the point is that there's no bar to the Commonwealth's petition here. That's the point. It's
Except maybe due process.
well, again, I don't think due process I mean, as I said, if this violates due process, then due process would encourage people to commit crimes in other jurisdictions so that they can avoid an SDP commitment. So, for example, if he committed like a Connecticut crime, and he had a term of incarceration of any length, and then he was ordered to serve the Connecticut sentence, under Gardner, he would be beyond the reach of Massachusetts until he committed another Massachusetts offense. Because once he's in the hands of another sovereign, Massachusetts cannot file a 123A petition against him.
So you're saying that would actually encourage an individual to commit, let's say, even a petty crime or some sort of crime and be incarcerated in another state just to avoid the possibility of a 123A petition?
That would be a potential consequence. I mean, once you're outside of the Massachusetts prison sentence, or once you're no longer held by Massachusetts on a Massachusetts sentence, Massachusetts can't file a 123A petition against you. So if you structured your sentence so that it was served, that you had a out-of-state sentence somewhere else, and then you went to go serve that sentence, then you couldn't be, under Gardner, you couldn't be made to face the petition.
So
I understand how you might want to structure how you serve your sentences on and after or concurrent in different jurisdictions. I guess I'm having a hard time understanding how anybody would be encouraged to commit a crime to avoid potential civil commitment in Massachusetts. But
well, the crime would have a particular end date. The sentence in the other jurisdiction has an end date that you know. Yeah. This doesn't. And also, I'd point out in Shedlock, again, Shedlock doesn't describe the current statutory scheme, but for what it's worth, Shedlock, one of the things that the court noted in Shedlock was if the Commonwealth was required to file the petition at the end of the qualifying sentence under the 1999 version of the statute, then it would encourage defendants to commit crimes while they were in a Massachusetts prison or jail to avoid the SDP petition. So that was one of the things that this court noted in Shedlock.
Okay.
So you say commit a firearm offense in Connecticut where you might subject yourself to a mandatory, 18-month sentence rather than expose yourself to an indefinite detention in a state court.
Exactly. Mm-hmm. And reading the statute in the way that the defendant says could lead to that result. And I don't think due process requires that outcome. So,
okay. All right.
Unless there's any more questions.
Well, I'll see if there are. Judge Milkey, any more questions? No. Judge Desmond?
No.
All right. Thank you both very much. We appreciate your appearing in this manner, and stay safe.
Thank you. Thank you very much.
We are live.
Thank you very much. All right, good morning, counselors. Thank you both for participating via Zoom today. We know doing so is a challenge. We ask you to be patient with us if we have any technological difficulties, and I can assure you on behalf of the panel that we will be patient with you as well. Before I introduce the panel, I just want to say a couple of things. And first and foremost, we hope that you and your families are well, that nobody has become ill, and that you're all doing all right. Second, I'd like to thank the appeals court team for developing and implementing this platform so that we can continue to hear cases and move cases along despite the challenging times. Third, I just want to remind you that although we are on a different environment than usual, we are going to be conduct the oral argument just as if we were in the courtroom. The same rules of appellate procedure apply. You each have 15 minutes to address the issues in your case. There is no rebuttal. You can be assured that we have read the entire record that's before us, which is quite voluminous in this case, actually, and that we're ready to ask you questions and talk about your case. So the panel before you today is myself. My name is Ariane Vuono, Justice James Milkey, Justice Kenneth Desmond. And with all that said, I'm now going to call the case officially, Commonwealth versus ELIEL Figueroa, 2019-0752. And Counselor, Attorney Scapiccio, please begin.
Thank you, Your Honor. Good morning, Your Honors. My name is Rosemary Scapiccio, and I represent the appellant in this case, ELIEL Figueroa. There are three issues that I'd like to try to get to today. The first one is whether or not evidence that Figueroa was the target of a large-scale heroin operation and that the detectives knew Figueroa was the leader of that large-scale drug operation constituted impermissible opinion evidence that bore on the ultimate issue of the trial, whether or not the trial judge was, or the motion judge was in error in finding that the trial counsel was not ineffective for failing to file motions to suppress that he didn't believe he had standing to do, and finally, whether or not the bad acts evidence that was introduced in the form of drug drops was impermissible. Now, with respect to the first issue, the issue regarding the opinions of various detectives and police officers who testified.
Let me just ask you about, if I may, I'm just going to interrupt you for 1 second, Attorney Scapiccio, because you framed it as the Commonwealth knew that, or the detectives knew that he was the heroin leader. Was it that they knew it, or was it that they believed it and they were trying to prove that?
It was that they told the jury that they knew it, expressed as an opinion. And they had no right to do that because, and I think this court has been clear that they had no right to do that, because what essentially happened in Mr. Figueroa's case is that the way that the evidence came in wasn't based on actual evidence. It was based on opinions of police officers who were involved in the investigation, who testified both as percipient witnesses and as witnesses who were offering their opinion based on evidence that, or issues that they actually observed. And so in essence, what happened here is by allowing this evidence before the jury, the Commonwealth's burden of proving both the identity of Mr. Figueroa and his alleged intent to distribute this heroin was proved by opinion evidence as opposed to actual evidence. And the way that came in this case is that almost every witness who started their testimony with a statement elicited from the Commonwealth that suggested that it was their belief that Mr. Figueroa was the target of a large-scale drug operation. It goes on, the testimony goes on to suggest through opinion testimony that the identity of Mr. Figueroa as Tony was corroborated by a confidential informant who was never ever disclosed and certainly didn't testify at trial. And based on the confidential informants' conversations with the detectives, they were of the opinion that Figueroa was the same person as Tony. In addition,
can I interrupt for a
Sure.
moment? There is no argument here, is there, that the evidence was insufficient, correct?
No, the evidence, well, with respect to insufficient, if you take away the opinion evidence, certainly it was insufficient. I think we say that in our brief. If it weren't for the fact that the court allowed and the Commonwealth elicited the opinion evidence, then there would have been no evidence to suggest he was the identity of Mr. Figueroa and or the fact that he had an intent to distribute.
So you would discount what is traditionally considered evidence, observations conducted, surveillance observations and things of that nature.
But the surveillance observations, Your Honor, did not suggest what their opinion said. In other words, their surveillance observations didn't suggest that Mr. Figueroa was the leader of any organization. What they saw in their investigation, it was a month-long investigation, they saw him 3 or 4 times, twice leaving the gym, which doesn't suggest he's a leader of any organization, once going in and out of an apartment that they say was associated when he had a bag with him, still doesn't suggest he's the leader of any organization, and another time in the company of someone who they labeled a runner of Mr. Figueroa. And again, the labels of runners and workers of Mr. Figueroa are labels that the detectives put on these people to, again, suggest their opinion that Mr. Figueroa was the leader of a large-scale drug operation.
Well, don't the investigators, one, get to explain why they're zeroing in on Mr. Figueroa versus anybody else? And
they do under certain circumstances.
Let me just finish, if I may.
I'm sorry.
Don't they get to kind of explain why it is we're zeroing in on this particular person? And then two, and you may have been clearer than I received it, but it seems you're arguing kind of the weight of the evidence versus the admission of that evidence.
No, I think I'm arguing both the weight and the admissibility of the evidence, Your Honor. But with respect to your first question, isn't the Commonwealth allowed or the detectives allowed to say why they zeroed in on a defendant? If in fact a defendant raises a valid Bowden claim and suggests that somehow the police didn't do an investigation properly under some circumstances, and we have to deal with Wadsworth, but under some circumstances, the Commonwealth can introduce evidence, but it has to be actual evidence, not conclusions or opinions. And the difference between what happened in this case and what happens normally is that what was introduced in this case, first of all, came almost at the beginning of every officer's testimony. The beginning of their testimony started with their opinion that he was the target of this investigation. And that wasn't in response to any Bowden argument by any defense attorney, at least at that point, because he hadn't even been cross-examined at that point. But beyond that, the substance of what they were using in order to raise this Bowden defense was their conclusion that Mr. Figueroa was the leader of a large-scale drug operation. That's not supported by the evidence. In fact, it's dissuaded by the evidence in terms of what they actually saw and what they actually did as compared to what their opinion was. So I agree with the court that in some circumstances, Bowden is appropriate. But in this case, Mr. Figueroa's defense was, I wasn't there, you have the wrong person. It wasn't necessarily a full-scale Bowden defense. And I don't think this court or the SJC has come to the point where anytime a defense attorney does their job and cross-examines a police officer or a detective investigating the crime, that they open the door to everything that the detectives did during their investigation. And I think that's where Commonwealth versus Wadsworth comes in. And I know that I filed a reply brief because Wadsworth came down after I filed my initial brief. But what the SJC says in Wadsworth is that it's not carte blanche. That if you do raise a valid Bowden defense and you suggest that the police officers aren't doing their job in some concrete way, then the Commonwealth can actually introduce evidence, but it has to be evidence and not conclusions. And the problem with what happened in Mr. Figueroa's case is that it was conclusions and not actual evidence. If you look at what they said about Mr. Figueroa were all conclusions based on evidence that wasn't before the jury. The conclusions that these individuals were runners and workers. The conclusions that they were confident that Figueroa had the target phone. The conclusions that they knew Casquillo was a fake name for Figueroa. The conclusion that the identity of Tony was from the CI. all of those conclusions aren't actually based on any evidence in the case that was put before the jury. It was based on the detective's opinion. And that's the crux of the problem with this case, because if the Commonwealth can be relieved of its burden to actually produce evidence to support its position, then what's the purpose of the trial? If you can have a detective, if you cross-examine a detective and say, did you look at this particular person? Did you do that? And that opens carte blanche for the Commonwealth then to get up and say, tell us what you think about this defendant. And then they get to say, I think he's the leader of a large-scale drug operation.
Well,
I think he is Koskilo.
With respect to the target phone, didn't they, there was some concern about who had the target phone. And toward that end, didn't they take the number and have one detective dial the phone while they had eyes on the defendant who was in a different place? I think he was in the mall actually at that time, or in the gym someplace and saw him.
In the mall, you're right, Your Honor.
And they saw it kind of, you could infer that it was his phone ringing because they said, call it. And then he went to the phone and checked the phone. Wasn't that evidence before the jury?
It absolutely was. But here's the problem with the way it came in. They didn't have their expert, who they designated as an expert, say that scenario leads us to believe that it was Figueroa who had the phone. Instead, they did exactly what this court says you can't do, which is they took a precipient witness and they put him before the jury and they say, this is what I saw, and then let me give you my opinion on what I saw. And my opinion on what I saw means that this guy is Koskilo. And he can't do that. That was for the jury to determine whether or not he was in possession of that phone.
Well, I know you characterize it as opinion, but can't they say, based on what we observed, this is why we did what we did? It's not opinion, it's we saw this, and as a result of that observation, our next step was whatever the next step may have been. That's not opinion, that's...
But I disagree with you in terms of the way that it came in this case. I think in some cases they can do that, but what was it based on in this case? If you look at all of the case law on expert opinions, first of all, designate them as an expert, which neither of these two detectives were designated as an expert. So nobody understood they were going to introduce expert opinion. Number two, with respect to expert, especially police officer testimony, you can't have a police officer be a precipient witness and an expert at the same time. You can certainly have a police officer say, this is what I observed, and I observed him take something out that looked like a telephone. You could absolutely do that because you observed it. But you, as the precipient witness, then can't take that step to say, and I concluded this, because that's an opinion that invades the fact-finding process of the jury.
Is it permissible for a veteran detective who has 25 years of experience to draw on his experience in the course of his investigation? Or you're saying that makes him an expert?
Well, I'm saying in this case, based on what they did, certainly their opinions came across as expert testimony, Judge. I'm saying not in every case, but certainly in the facts of this case, that they were both precipient witnesses and offering opinions. And I'm not saying that they couldn't have put their own expert on to say that scenario where he answered that phone is consistent with our experience of him actually having possession of that phone or anything like that. But they can't, in my opinion, take a position that they saw something and then they're testifying as an expert about it, because that relieves the Commonwealth of their burden of proving both identity in this case and proving intent to distribute.
Counsel, hasn't the SJC said, while it's disfavored to have a precipient witness who's also an expert, it's not per se invalid?
Well, it's invalid in some circumstances, Your Honor. And I believe what this court and the SJC said, the times that it's invalid is when you have that police officer cross the line between precipient witness and expert. That's why you designate an expert. That's why the expert is someone different from the people who are working the investigation, so that you can, as a defense attorney, prepare and cross-examine for that particular expert. So you're right in certain circumstances, but on the facts of this case, especially when you consider Wadsworth, because everyone is making the assumption in this case that Mr. Figueroa raised a valid Bowden defense. Now, Bowden defense, if you actually read Bowden, and I know everyone has, is limited to scientific testing, okay? So there was no valid objection to any scientific testing in this case. There was a question about whether or not they investigated Mr. Casquillo, and did they find out who Mr. Casquillo was? Absolutely, the defense attorney asked those questions, as well he should have. But that does not give the Commonwealth carte blanche then to open up their entire investigation and tell the jury everything they did so that they could fix their case to convict Mr. Figueroa. And that's exactly what they did here. They offered opinion after opinion after opinion, suggesting the opinion on identity, suggesting the opinion on intent to distribute, all of those essential elements of the crime, they offered through detectives' opinions. And I'm suggesting that we aren't there yet in Massachusetts where we're going to allow a district attorney's office or the Commonwealth of Massachusetts to convict someone based on a detective's opinion because he has 25 years of experience. That's not what the law says. The law says they actually have to produce evidence. And if they want to get an opinion before the jury, they have a way to do that. It's designating an expert and asking the expert based on hypothetical questions what the situation arises. When you blur that line, and I think the courts are clear, when you blur that line, it affects the defendant adversely, and that's what happened in this case. And I know I'm sorry.
No, I just want to ask you a question. So before we run out of time here, what you're about to do is these issues are really all raised in the lens of the motion for a new trial and based on ineffective assistance, correct? In other words, this is both a direct appeal and an appeal for the denial of motion for new trial.
It is. It combined the direct appeal with the motion for new trial, and the motion for new trial focused in on. If I could continue, because I know I'm going to run out of time, Your Honor. But the motion for new trial focused in on the ineffective elements for the trial attorney not recognizing these opinions and objecting to these opinions. So my client then gets a much more strict standard.
So you're saying both that the trial judge erred by allowing this in and should have sua sponte intervened, as well as the fact that the counsel was ineffective for not objecting.
That's correct, Your Honor.
Okay.
And if I could just briefly touch on the dead drop issue.
Actually, your time is up. So let me just see whether or not the panel has any questions. Judge Milkey or Judge Desmond, any questions? No, I don't see any. Thank you very much. And nothing will be forfeited. We have your brief, which is very comprehensive, and you can be assured that all the points that you made there are will be considered.
Thank you, Your Honor.
You're welcome. Counselor for the Commonwealth.
Good morning, Your Honors. Houston Armstrong on behalf of the Commonwealth. May it please the court. This court should affirm the denial of the defendant's motion for new trial and his convictions. Just very briefly, the motion judge did not abuse her discretion in denying the defendant's motion for new trial without an evidentiary hearing because the defendant did not show and cannot show that filing a motion for new trial, a motion to suppress would have been successful.
She was also the trial judge, is that right?
Yes, sir. Yes, Your Honor. The Detective Kelly's testimony was entirely proper, relevant, and admissible. And lastly, the dead drop evidence that was testified to was also relevant and admissible, and neither of those would have withstood any objections. So I'll turn to where my sister spent the majority of her time on Detective Kelly's testimony. I think it's important here, well, it is important here to remember what the ultimate issue of this trial was, and that is whether or not the defendant exercised dominion and control over the heroin at 258B Blue Ledge Drive. The issue was not whether or not he was the leader of the drug organization or whether he was the target of the investigation. The issue is whether or not he had actual or constructive possession over the heroin at 258B and the cocaine. And that's important because when you look at the testimony that my sister cites to where they describe the target of the investigation, in large part, they're just saying who they were investigating. Specifically, my sister points to two sites on transcript 2 at page 171 and 217, where those are police officers who were just involved in the execution of the search warrant, where they're saying what they were doing on that day. We were there to help effectuate the search warrant, and we were waiting on the targets of the investigation to show up. One of them is talking about a target inside 258B, who ultimately was Luis Sosa, not the defendant in this case. The other sites that my sister points to in her reply brief all go to what the DEA was investigating, the actual investigation. And Justice Desmond, your question, I think, hit the nail on the head, is that these were not opinions of police officers about who committed a crime. These were observations and explanations about what they saw real time during this investigation. And none of that went to whether or not the defendant had actual or constructive possession of the drugs, but it painted the entire picture of this large, very well organized heroin distribution organization.
But if, counsel, if the jury were told that he was the leader of this group, wouldn't they be more likely to find that he had possession or control of the drugs at that site?
Potentially, but the part of your hypothetical which I disagree with is that the jury was ever told he was the leader. The discussion of a target or who the investigation was focused on is different than being the leader. My review of the transcripts, I don't recall the defendant ever being called the leader. I believe on transcript 2, page 240. I'm just trying to pull it up now so I have the correct words for you. And this is coming from Detective Kelly's testimony after the prosecutor asked, in the fall of 2013, were you involved in a certain investigation? Yes. Who were you investigating? We were investigating a heroin distribution organization out of the North Shore of Boston, which went by the name of Tony, aka ELIEL Figueroa. This is just an overview of the investigation, and it also is the truth. They were investigating the defendant for this large-scale drug distribution. And that statement by Detective Kelly, Justice Milkey, I don't think is as powerful as in your hypothetical that he was the leader. And notwithstanding any of that, the evidence against the defendant as the leader of the organization was sufficient and abundant, even as Justice Desmond pointed out about the putting the target phone in the defendant's hands. There were multiple controlled buys, all of which were orchestrated by using that target phone. The police were able to put that target phone in the defendant's hand that on November the 3rd, when they were in the marshals, yes. And moreover, all of that went to the defendant's being able to exercise his dominion and control over those drugs. And if there are no further questions on the Detective Kelly's testimony, I'll just briefly address the motion to suppress and the dead drop evidence.
Well, I'd like you to talk a little bit about ineffective assistance. I mean, here's an attorney who didn't file a motion because he really had a misunderstanding of the law. What do you say in response to that?
That does not rise to the level of ineffectiveness because the defendant has the burden to show that a motion to suppress would have been viable. And that is the defendant's burden, and that comes from Commonwealth versus Comita. That's 441 Mass at 86. This is the defendant's burden to establish that a motion to suppress would have been viable. And counsel can't be ineffective for failing to file a futile motion. And here, that's exactly what a motion to suppress would be, based on the four corners of the affidavit, and which is before this court. And I would say that this court could review the four corners de novo, just as a motion judge would. And that affidavit easily establishes probable cause to believe that there would be drugs or drug-related paraphernalia within the stash house at 258B Blue Ledge Drive. Specifically, there was a nexus to 258B, and that came from the Stony Brook employee who said, you know, I know the police showed the employee a picture of the defendant, and he said, yes, I know that is Samuel Carrasquillo, who rents the apartment at 258B. Police then, they didn't stop there, and they continued their investigation over the course of that month to determine that the defendant was actually going there, to determine that the defendant was orchestrating everything that was going on, and had the ability to go into 258B and exercise control over those drugs. There was also a proper nexus to 10 Unity Way, simply that the defendant had recently been arrested for narcotics offenses, and that listed his address as 10 Unity Way. 10 Unity Way was also not under the defendant's name. It was rented to his girlfriend at the time. I also think that an inference can be drawn that the defendant did not have anything registered in his name, in the name ELIEL Figueroa, and that is an inference that he was attempting to hide and disassociate himself from the cars that he was driving, the black Ford Escape, the green Ford Explorer, the white Acura, the cell phone that he had, and 258 Blue Ledge.
Your sister might say that is impermissible opinion evidence.
So if we may just hold 1 second, Your Honor, because that, whether it's opinion evidence or not, would be talking about the trial testimony that came in. My point about all of that was for whether or not motion to suppress would be viable. So we're just looking at the motion to suppress and not the trial testimony. And again, you know, looking at this motion to suppress, we're looking at whether or not there's probable cause to believe drugs or narcotics would be located at 258B, which there easily was under this extensive affidavit. The second claim about the motion to suppress is that the confidential informant, who, while there were multiple, the one that my sister points to was the Stony Brook employee who identifies the defendant as Samuel Carrasquillo. That was corroborated, as I previously mentioned briefly, through the abundant independent police corroboration. The police showed the employee the defendant's RMV photograph, and that employee, who has the basis of knowledge because he's a security guard and because he works at the Stony Brook Commons, he has the basis of knowledge to say, yes, I know that person as the person who rents 258B. The police then confirmed through GPS data, through the ping warrants, through independent surveillance, all that the defendant was coming and going multiple times from 258B. There was a lot of traffic between 10 Unity Way and 258B. There were packages dropped off at both locations. And that investigation showed that 258B was the focal point, was the stash house. So the Stony Brook employee's statement was satisfied as Aguilar Spinelli because there was independent police corroboration. And turning to the last issue with the remainder of my time, the dead drop evidence was properly admitted. First of all, there was no objection to this evidence coming in. And second of all, it was relevant to show the defendant's intent, common scheme, actual constructive possession, and absence of mistake. And that was precisely what the trial judge ruled at the time, and precisely how it came in. Now, Detective Kelly did state, you know, that during the investigation on the October 21st incident, when they saw the drugs thrown from the car and they were recovered, he called them a dead drop. That, I think, to Justice Desmond, your point to my sister was that we're looking at that through his lens as a veteran narcotics officer. Him calling it a dead drop It's not impermissible, and it's not an opinion. It's just what happened. And the dead drop was further explained by the drug expert, by Sergeant Detective Feeney, and that's at the transcript, volume 4, pages 83 and 84. So there was no objection to the dead drop evidence. It was admissible to show the defendant's control over the drugs, and it was properly admitted. And for all of those reasons, if the court has no further questions, I would ask this court to affirm the defendant's convictions.
Any questions from the panel? Justice Milkey, no. Justice Desmond, no. I see no questions. Thank you very much for your argument. Thank you both. We'll take the case under advisement and get back to you as soon as we can. All right.
Thank you, Your Honor. Stay
Stay
safe.
well and be
Thank
safe.
Thank you.
All right, we are live.
Okay, thank you very much. Good morning, and thank you for participating in your oral argument today via Zoom. We understand that doing so is a bit of a challenge. We ask for your patience if we have any technological difficulties, and we can assure you that we'll be patient with you as well. Before I introduce the panel, I just have a couple of things I wanted to say. And first and foremost is that on behalf of the panel, we hope that you're all well, that your family members are well, and that you are weathering this pandemic as best as you can. Second, I would like to thank the appeals court team, if I can call them that, who have developed and implemented this platform, which has permitted us to go ahead and do our work despite these challenging times. And third, I just want to remind you that despite the fact we're on a different platform, we'll conduct oral arguments just as if we were in the courtroom. The same appellate rules of procedure apply. You each have 15 minutes to argue. I understand that Attorney Nestor and Attorney Basu, am I saying it correctly? How do you pronounce your name, sir? So, ma'am, I'm sorry. Excuse me. I didn't actually hear you.
That's correct, Basu.
Basu, okay. We'll be sharing their time, 7.5 minutes each. You can be assured that we have read all the materials that have been submitted to us, and so that we're ready to hear your argument. The panel today is comprised of myself. My name is Ariane Vuono. We're joined by Justice James Milkey and Justice Kenneth Desmond. So I'm now going to call the case officially, which is Henry Comstock and others versus the Gloucester Zoning Board of Appeals, 2019-1163. Okay, and we'll start with Attorney O'Connell.
Good morning, members of the panel. Can you hear me?
Yes, we can.
Thank you. May it please the court. Liam O'Connell for plaintiffs, appellees, Henry Comstock, and others. The trial court summary judgment in favor of the plaintiffs was correct. Despite not requesting it, the plaintiffs opposed the the private defendants, in this case, the Irwins, the applicants for the special permits and variances. The plaintiffs opposed the Irwins' motion for summary judgment, which was filed somewhat prematurely in the sense that it was before the end of discovery. And there was some outstanding discovery issues, including a allowed motion to compel the reopening of discovery to redepose both the private defendant Irwins in the matter. So that was still, and other things that was still open when this motion for summary judgment was filed by the Irwins. The motion for summary judgment essentially asked the court to allow summary judgment in their favor as a matter of law because they did not think they needed any variances at all. All the Irwins believed they needed was a special permit, a Section 6 special permit, and a special permit pursuant to the Gloucester zoning ordinance to increase its maximum allowable height. The court's interpretation of both Dedrick and the Belalta decisions, which it cited throughout its memorandum of decision, are correct. Dedrick stands for.
Can I interrupt for a second? Are we going out of order?
I believe we may be.
Oh,
I thought so too.
I just went with it.
I apologize. I apologize. I can't see you in a courtroom, and so I apologize. Well, in all fairness, I think that it makes sense for us to stop for a moment. It's only been 3 minutes, 3.5 minutes into the argument, and we will start with Attorney Nestor and Attorney Bazoud. I apologize.
Thank you.
I apologize. So let's see if our law clerk who's here can hear us, and she can change. Thank you. Can you reset the clock for 7.5 minutes? And we're going to restart the argument. Great. Okay. Attorney Nestor, then you're going first.
Thank you. I represent the homeowners Robert and Pamela Irwin of 132 Wheeler Street. I would submit that the crux of this case is whether the trial court was correct in its determination that a request for an additional height created additional nonconformity and then required a variance, or whether the request for an increase in height was governed by the city's specific bylaws for a height exception and does not require a variance. Our position is that because the city has a specific bylaw that deals with height exceptions and does it by vis-a-vis a special permit, that a variance is not required, and that Bellotta control, a deeper control, and the case should not have been dismissed. In actuality, no variances were required.
If it were a conforming structure, would a variance be required, Attorney Nestor?
No. I would submit again that no variances should have been required. Gloucester zoning ordinance specifically addresses the issue of a height exception, which I think the trial court misinterpreted, unlike Chatham and Diedrich, and therefore the ZBA, because it invoked a special height exception and because it made specific findings of fact to support its position for a height exception, that was all that was required for the height, and that it could proceed from there, and the ZBA correctly provided that way, and no variance was required. In fact, Diedrich was very specific that it was determined that under 545 that we had a special exemption there, that no variance was required, which is what unfortunately the trial court missed in its decision. The same thing applies with Bellotta, because Bellotta really allowed the ZBA to enhance the protections that were provided to single and two family houses. I mean, Bellotta made a determination that single and two family houses had a special protection, had a special requirement, and they frowned on it, and they looked in the entire history of the legislation, and they felt that requiring single family or two family houses to have both requirements for special permits and variances created an economic hardship on them, and therefore accorded the cities and towns at their election to provide special protections, which they did in this case because they gave them the permission under the special permit. You comply with the special permit, you could get the height variance. You need to understand that both in Bellotta and in Diedrich, my clients were in essentially the same facts as the other two cases. It was an old dilapidated garage which was coming down. They made a determination to rebuild it. It was exactly the same footprint. The only difference is they were going to raise the height. And one of the reasons they needed to raise the height for the building is because they needed to raise the height for the garage door to allow access to vehicles that may have been larger than were 50 or 60 years ago when this garage was permitted. There were no other changes. I understand that.
Counsel, I mean, to be absolutely accurate, isn't it uncontested that the eaves of the roof will extend 10 inches further into the side yard?
That's true, but what is ignored is that there's in the ZBA, the zoning ordinances, there's a permission that you can extend as long as it's not 3 feet. If it's less than 3 feet, the overlap of the eaves doesn't count.
Well,
This case is-
isn't there an ambiguity in that ordinance, and we haven't heard the ZBA's interpretation of it? Because your brother has a different reading of that ordinance, and frankly speaking, only for myself, the ordinance does seem a little ambiguous on that issue.
I mean, I would submit the ordinance is really not ambiguous, and my brother even points out that, and he cites that it's 3 feet. This is only 10 inches, and I would submit because it's only 10 inches, it's not really a further encroachment in the side setback as my brother would ask. If it was 3 feet, I would clearly understand. But if we're only talking 10 inches, and in fact, the ZBA affirmed that if you rotated it, it made it much more conforming with all the other garages in the neighborhood. That in fact, it was in a sense probably creating less of a nonconformity because it's now mirroring all the rest of it versus previously the way they had the pitch, it was going a different way.
But isn't your better argument simply that a municipality can extend an existing nonconformity by special permit, and that's in fact what the city did here?
Which is what the city in fact did. I mean, our position has always been is the Irwins only needed special permits to address the non-conforming building on the non-conforming lot. The ZBA was very clear, this is not one where they just voted for it. They went in and gave very detailed findings on both the requirement to allow them to rebuild on the property, in switching the roof line 90 degrees and granting them the height exception they were looking for. And as a result of the same, they've addressed the issues of the statute. They've also addressed the issues of 4086, and they've also kind of addressed the issues that both Bellotta especially talked about, is we're allowing you to do this without forcing significant expense and cost on a single or two family owner to try to improve the property. Understand, this was the garage that was probably going to come tumbling down in a few short years, and so this is probably in the best interest of both the neighborhood as well as my client, that the ZBA allowed them to rebuild same plot as before. Just the only thing different they're really looking for is the height. And I would submit this is what the ZBA thought about. Again, numerous members of the neighbors supported. There was no opposition at it. And as a result of Sam, I would submit that under Bellotta and Diedrich, the case law supports my client's position. It does not support the position of the trial court.
So it's going to go from 12 feet to 15 feet, is that right?
That's correct.
And by raising it to 3 feet, is it the COMSTOCK's position that impedes their view? What is the complaint?
There was no argument that it impeded their view at all. I mean, there was no opposition at the hearing. Their argument is not that it impeded his view at all. And there was no finding that there was any impediment of views in the decision of the ZBA that addressed it. I guess my time is up.
Actually, there was a finding to the opposite.
That's correct.
It wouldn't impede.
That's correct. Again, they addressed it in detail. This is not just a one line we've approved.
So the primary argument is just simply unlawful, not that they suffer any harm.
Right. That's correct. There was no allegation of any harm that is being sustained by the Donovans.
Okay. Thank you very much, Attorney Nestor. We can turn now to Attorney Basu.
Good morning. My name is Krishna Basu, and I represent the Gloucester Zoning Board of Appeals in this case. The decision by the Gloucester Zoning Board of Appeals was consistent with both the language and the principles articulated in the Diedrich and the Bellotta cases, and I'd like to speak about each of those. The Superior Court found that under the Diedrich case that if an additional nonconformity was going to be added to a piece of property, that a variance was required. However, if this court looks at the specific language in Diedrich, what the Diedrich court stated was that a variance was required if the proposed increase in height constitutes an additional nonconformity not otherwise exempted by the town bylaw. And it's the city's—
Counsel, I think we understand your argument on there, which appears to be the same as the private party. Can we jump to some other issues? On the 3 feet argument, if I don't know if you agree with me or not, if the wording of the ordinance is ambiguous, but does the ZBA have a position on how that 3 feet should be interpreted?
Your Honor, are you speaking about the increase in height of the building under the city zoning ordinance?
The extension of the eaves. You know, does it give a free ride to eaves that extend up to 3 feet, or is the abutter correct that you know, once you're past the setback, you don't get a freebie?
Thank you, Your Honor. I believe what the court is referring to then is the right side yard setback. Exactly. And it's the city's position that that specific issue was not raised before the Zoning Board of Appeals, but what the Zoning Board of Appeals did have was they had the plans, they had the diagrams, and it was their understanding that the right side yard setback was not going to be increased beyond the original footprint in the case. And so as the court stated, given that under the case law, under the city's ordinance, and under chapter 40A section 6, that there was not going to be a substantial detriment to the neighbors. And the city actually, you know, did examine that. So they did examine that principle, the Zoning Board of Appeals, as to the right side yard setback, and found that because it was not going to be intensifying the nonconformity, that what was required was a special permit. And the zoning board actually questioned whether a variance was required because there was no intensification. Okay. Even if there was an intensification, if it was going to be a little bit further than the original structure, then the standard would be a special permit.
Now, yet the city gave 2 variances from the setback requirements. Mm-hmm. The application that the owners filed does not appear to ask for variances. Is there any light you can shed on the city's decision to grant the variances?
Well, actually, looking at the application filed by the applicant, which is page 73 of the city's appendix, they did request, it's on page 77 of our appendix, that they required a extension for the right side yard setback. So that was in the application.
There's a box to check if you're asking for a variance. They didn't check that box.
That's correct, Your Honor. It's a bit conflicting because they did not check the box, yet they did note in the dimensional requirements for which relief was requested that they were requesting, you know, that it would differ from what the dimensional requirements are.
But isn't the special permit the relief from that setback requirement, since they were already in nonconformity with it?
Yes, Your Honor, that's correct.
Okay. How do you address the abutter's argument that the city, having chosen not to participate in the trial court, doesn't get a mulligan?
Your Honor, the city's position is that it's true that the city did not file a brief. The reason for that, and if the court looks at the briefs, which are part of the record that were filed at summary judgment, neither the motion for summary judgment nor the opposition takes any position on whether the city of Gloucester's height restriction, the 3.1.6, that an increase in height is allowed by special permit. That wasn't one of the issues. And frankly, all parties agreed, both the homeowner and the abutter, that the method of obtaining an increase in height was by special permit. And so for that reason, the city did not take a position. It wasn't argued in the briefs. It actually wasn't argued at the hearing if this court examines the transcript. And it was not until the decision by the court, by the Superior Court in summary judgment, that this issue was first raised, was that whether a variance is required for an increase in height. And that issue is critical to the city of Gloucester, and the reason that we filed a brief at this stage to protect that, because as the court knows from the Peralta case, the Peralta case held that we want to protect homeowners that have older homes in Massachusetts, so that if they're non-conforming, they are able to, as in this case, if it's an older dilapidated home, to make improvements. And to ask a homeowner to go through the process of a special permit, no finding of substantial detriment, and then also a variance is just a lot of hurdles to go through that the courts have held should not be the case. And in Gloucester, in keeping with that, in 3.1.6, the height section of Gloucester's ordinance is consistent with Chapter 6. It uses mirrors some of the same language, that it's a special permit that should be the relief for an increase in height rather than a variance. And so that is the reason that the city became involved at this case, to protect that section of our ordinance and to affirm that it is consistent with all of the case law, with both Dedrick and with Peralta, and that it is increasing the protection of non-conforming properties and allowing them to be reconstructed and altered, and also to not have an increase in burden to do that.
We're down to 7 seconds, so I'm going to assume that you have nothing else to add, and we will let you rest on your brief, okay?
Thank you very much.
Thank you. All right. Okay, Attorney O'Connor, you get to have a second go around.
Thank you, Your Honor. May it please the court, Liam O'Connell for the COMSTOCK Donovan's plaintiffs. I will respond briefly to both the defendants, appellants here.
Counsel, could
yes,
you actually start with what your standing is here? The only concern that I see in the record is about the drainage issues, and the ZBA dealt with that by requiring the owners to get a drainage plan approved by the city engineering department before they could proceed. Now, I note in the deposition transcript, there's a controversy about whether or not they were going to do that, but isn't the remedy there to seek enforcement if they start proceeding without that, as opposed to challenging an approval that incorporates the protection of the only concern your client has raised?
Well, I think, Your Honor, I think the concern regarding the drainage was raised initially, and I think there are other concerns. One, major concern being the property line between the two properties is in dispute, and the plans which the Irwins had submitted to the city of Gloucester don't reflect other plans that they have that show the actual garage's location in relation to that property line, which includes the retaining wall that runs down the property line, which their other plans, which we learned through discovery, show that a portion of those retaining walls are actually on Donovan's property. So as far as there are other concerns, as far as the standing for the section or the 40A section 17 appeal goes, I think, Mr. Donovan appealed this because the applicant didn't request the appropriate relief and didn't receive the appropriate relief in order to do this job. And, the Zoning Board of Appeals, the Special Permit Granting Authority, didn't even have all the information before it when it made its decision.
Do you agree with your sister's comment that the judge raised the height issue requiring a variance sua sponte after the hearing?
I do. I believe she brought it up during the hearing. I believe it was discussed during the hearing. The transcript will show that. The underlying motion for summary judgment by the Irwins was an argument saying that they don't need any variances. They just need the special permit under Section 6 and the special permit for the increase in height. And their argument was that we don't need any variances. That was a completely in opposition to the Zoning Board of Appeals decision. So the city of Gloucester.
Just stop there, please. I mean, the ZBA did say, we're not sure if a variance is required, but here is one anyway on the setback issue.
And I think the reason, and I believe this is in my brief, I think the reason why the ZBA said that is because of footnote D in the Gloucester zoning ordinance section 3.2.1, which discusses accessory structures and their location to the principal structure and the road. And if the accessory structure is not, or is closer to the street than the principal structure, there's a footnote in the dimensional diagram, which mandates that, or, says that the garage can, or the accessory structure cannot exceed 12 feet unless it abides by the principal structure's setbacks. So I think the ZBA, in doing what they did, was interpreting, was realizing that because they wanted to go above the 12 feet, they were creating a new nonconformity, and then they had to abide by the footnote D setback issue with the principal structures. That's why that is there. Essentially, I think what the ZBA did is they thought they lost their protection, their prior existing non-conforming protection, once they wanted to go above height and above the 12 feet to create a new non-conformity. They lost their protection under section 6, and then they had to abide by the two setback issues. So I think that's why they did it, and I think it's clear if you look at what they applied for and what they gave them, or at least it shows some intent from the Zoning Board of Appeals that's the reasoning for doing that. There's been a lot of talk about Dedrick and the fact that Gloucester zoning ordinance allows height in a building to be allowed to exceed the maximum allowable height by special permit, whether it's a conforming structure that was asked in the beginning of the argument. That's true. A conforming structure can apply through the city of Gloucester for a special permit to exceed its maximum allowable height. And that right there is for a conforming structure. For a prior existing non-conforming structure, what I submit to the court is that the Zoning Board of Appeals lacks authority to issue a special permit to allow a new nonconformity for a prior existing nonconforming structure. They lack the authority to do it. And, Belalta discusses this quite a bit. It goes through the legislative history and it discusses how when an applicant, wants to create a new nonconformity, they lose those protections.
But how is this a new nonconformity if under the height provisions of the ordinance, they secure approval to go above the 12 feet and an approval process that is open to the owners of conforming and non-conforming structures alike?
Because it's still a nonconformity in the dimensional diagram. And one of the cases which the city of Gloucester referenced was Emmons v. Board of Appeals, Emmons v. Board of Appeals, which is 27 Mass Appeals Court 630. And on page 634 of that decision, it provides a brief legislative history on exceptions. And I would submit to the court that the special permit procedure, which allows someone to go above the maximum allowable height, that is not an exception to the ordinance. That is a method, a process. And I think the court does a nice job of going through the history there and explaining that, essentially, in 1954, when they amended the Zoning Enabling Act, they abandoned the term exception, which many authorities regarded as a misnomer, since no exception is typically involved in permitting such a use. Rather, the special permit is granted only for uses specifically authorized. So it's an authorization. It's not an exception to the ordinance. And Dedrick is clear that any new nonconformity, which is not accepted requires a variance. Therefore, the protections granted to an applicant or a homeowner under Section 6 are not applicable when there's a new nonconformity. The zoning authority or the special permit granting authority lacks the authority to grant an applicant the ability to create a new nonconformity with just using the burdens of a special permit. They need to have the burdens of a variance, and that goes back to the intent of the Zoning Act to, over time, decrease the amount of nonconformities. So that's where I think the court was right. The trial court was right.
Okay, say just hypothetically, we were to disagree with you on the reasoning that the Superior Court judge used. What happens next? Because at least as I read the way that the issues played out in Superior Court, you didn't really, in opposition to the summary judgment motion, challenge the validity of the special permits. Instead, the argument was focused on potentially more fertile ground, namely the granting of the variances. First of all, do you agree with that characterization?
I think that's pretty fair. I would say that the summary judgment motion was a legal argument filed before the end of discovery. So there was still ongoing discovery as these motions and oppositions were filed in relation to real facts on the ground, no pun intended, about where everything was in relation to the lines, where the eaves were, which, it's clear to me that the ZBA missed that. And the reason why they missed the eaves issue is because, and the record is clear on this, the plans which depicted the eaves were never given to the ZBA. And that's clear on the record. So I'll get to the eave issue in a second, but to answer your question, I do think that's fair. And the reason why is because we weren't dealing with any of the facts. We were dealing with the legal argument. The legal argument was we don't require any variances. All we require are these 2 special permits.
Okay, but if we were to disagree with you and the judge on the special permit with regard to the height, why did they need a variance with regard to the setback? Because under Gale and Belalta, the courts have recognized that you can extend an existing nonconformity through a special permit.
Correct. I think the reasoning is because of the footnote D, which I mentioned earlier. Now, this is a garage. No court has held that a accessory structure that is not attached to a residential 1, single or 2 family home is protected by Section 6. So this is not a Section 6 protected structure. The only reason why we're even talking about Section 6 is because the Gloucester Ordinance allows accessory structures like a garage, accessory to a residential single or 2 family, to be protected by Section 6 within the ordinance.
Well, isn't it Gloucester's right to do that so long as they do so clearly?
Absolutely. Gloucester can I think I titled the caption, Gloucester can giveth and can taketh away. And they gave the Irwins the opportunity to be protected under Section 6, but they still have to abide by and comply with the rest of the ordinance. And the rest of the ordinance is very clear that if you want to have an accessory structure that goes above 12 feet, you are going to have to abide by the principal structure setbacks. So what I submit to the court is once they applied for a special permit to exceed the maximum allowable height under the ordinance, they then had to comply with the principal structure setbacks, which they don't, and that's why they gave them the variances for the principal structure setbacks. Now, obviously, there's questions of fact about whether or not those variances are enough and where the actual property line is and the eaves issue, but that's why those variances are there, because they lost their protective status. Once, Section 6 deals with tearing down and reconstructing a single or 2 family home and, expanding those issues those existing nonconformities, expanding or modifying them. And that's what it deals with. It doesn't deal with, at least, vis-a-vis Dedrick and Belalta. And, there's plenty of decisional law cases from the land court and the Superior Court, which also have held this. It doesn't protect them once a new nonconformity exists. And
can I ask a question about your Section 6 argument?
Yes.
Are you familiar with the Bjorklund case?
I am, Your Honor.
Well, then, as you know, it lists a number of small-scale changes that could be allowed as a matter of right, at least when the issue isn't a dimensional requirement, but an undersized lot. Some of the examples they use involve accessory structures, like the construction of a shed.
Mm-hmm.
So why doesn't that, at a minimum, strongly suggest that Section 6, indeed, in terms of the extra protection given to residences, it also applies to accessory structures to such residences?
Well, I think Bjorklund, the minor structures that they talked about, they did talk about sheds. They were very clear that 1- and 2-car garages, a single story, they were very clear, 1 or 2 car, single story garages. And, when you look at the case and you read the facts of the case, all those garages were attached to the structure, the residential structure. They weren't accessory structures. The only accessory.
In the list that Bjorklund set forth,
yes, and
talking about garages, it doesn't seem to say whether they're attached or detached, does it?
The facts of Bjorklund were talking about an attached garage. So I think there's an inference there, but they don't, they talk about sheds, yes, those could be things that are protected under Section 6. If the court is going to say that all garages for single and 2-family structures are protected by Section 6, then that potentially could expand that. But as of right now, we are stuck with the fact that if there's a new nonconformity, which there is, there is a new nonconformity here, and the Bjorklund land court case, which was essentially affirmed by the appeals court, the Bjorklund land court case cites Dedrick and says specifically that variants are still required for the creation of any new nonconformity. So this is a new nonconformity, a variance is required, and they lose their protective status. The existing structure is protected, not the changes when there's a new nonconformity. They lose their protective status, and then they have to comply with the ordinance.
So your time is up. I'm just going to see whether the panel has any further questions for you. Desmond, no. Milkey, Judge Milkey, no?
No.
Okay, thank you very much. I'm sorry for the slow start, so to speak, on this case, but I appreciate your patience. Thank you all, and stay well, be safe, and we'll take the case under advisement and get back to you as soon as we possibly can. Okay?
Thank you.
All right, we are live streaming.
Thank you very much. Good morning.
Good morning.
Thank you both for participating in the arguments today via Zoom. We recognize that it's a challenge for us and for you. We can assure you that we will be patient if you have any technological difficulties, and we ask that you be patient with us as well. Before I introduce the panel, I just want to say a couple of things. And first and foremost, on behalf of the panel, we hope that you're all well, that your families are well, that you've been staying safe, and that you're weathering this pandemic and as best as you possibly can. That's first and foremost.
Thank you.
Second, I would like to thank the appeals court team, if you will, who have developed and implemented this platform so that we can continue to forge ahead and hear cases despite the challenges that we face. Next, I'd just like to say that the arguments here will be conducted just as if we were in the courtroom. The same rules of appellate procedure apply. Each side has 15 minutes. There is no rebuttal. Thus far, we've had a number of arguments, and it seems to go pretty smoothly in terms of being able to determine who wants to ask, which judge might want to ask you a question. So I'm not concerned about that. If there's a small amount of talk over, we all understand that, and we can take care of it. You can be assured that we've read everything that you've submitted to us. And so we therefore look forward to hearing the points that you want to make to us right off the bat. So let me introduce the panel. With us is also Justice James Milkey, Justice Kenneth Desmond. As you can see by my square up there that my name is Ariane Vuono, and I'll now call the case officially. John Clement versus Laurie OWENS-CLEMENT, 2019-1307. And Attorney Hess, you begin your argument.
I don't believe you're required to stand, Attorney Hess, if you wanted to sit down, however.
I appreciate that, Your Honor, but I would like to stand because that's sort of how I have things set up, if that's okay.
Sure.
Absolutely fine.
Good morning, Your Honors, and may it please the court, Julie Hess for the appellant, John Clement. As Your Honors know, the trial court issued a judgment that my client, after only a 71-month marriage, must pay his ex-wife alimony for the rest of his life, not subject to any restrictions or time limits, even upon retirement age, which the statute requires according to Section 49F. And on top of that, the payor is himself disabled and having to pay the ex-wife from an asset entirely waived by her in the divorce.
If there were to be a changed circumstance with respect to your client, if he were to suffer a further disability, would he then be able to move for modification?
Well, I believe he would. However, Your Honor, part of my argument and in my brief is that we never should have gotten to this point to begin with. We got here to arrive at this place. The trial court ignored, with all due respect to the trial court, ignored well-settled law on waiver, on asset division, and the statutory construction of the Alimony Reform Act. So let's get into that a little bit. There's two main points that I really want Your Honors to hear. I know you've read the brief and there's many other points in the brief, but two are really important. And I think if we don't even get past those, then Your Honor, we don't even get to the point of necessarily another modification. The first is that in the parties' agreement, they waived past and present alimony and left the issue of future alimony silent. Now, there were other problems with the agreement too, but in McManus' case alone, the court held—
Can I just interrupt you for a moment? I'm sorry. Haven't the parties stipulated that the future alimony was not waived?
Yes, they did stipulate it was not waived, but even in McManus, lack of waiver alone does not mean that there was an intent of the parties to go forward on that issue in the future. And in McManus, the court said that that kind of ambiguity, leaving it silent, must be cleared up by the finder of fact, and then the trial judge must make findings as to whether or not it was able to be revisited in the future.
Am I not mistaken when I say that there was no such stipulation in the McManus case?
As to waiver?
Exactly.
Correct, Your Honor, but they did find that there was not a waiver. So it's the same thing. There was not a waiver, but the intent of the parties needed to be ascertained and the findings of fact must be made by the trial court. So yes, there was never a waiver by the parties explicitly, but let's look at the rest of the agreement. So the trial, the agreement was silent as to future alimony. There was merged waivers of past and present alimony, which how can you have that? A merger by its terms means it's modifiable. Waivers are not modifiable unless you find fraud or coercion, and that's under, I believe, the DeMarco case.
Doesn't the stipulation speak directly to the intent of the parties?
No, it does not, Your Honor. I think it's very silent on that point. It does not talk about intent to go forward. As a matter of fact, the case itself shows that my client, it showed that the intent was very different. My client testified to that. His counsel argued that. I was not trial counsel. His counsel argued that. And the agreement explicitly says that every financial arrangement was in that agreement at the time of the divorce.
But just a moment. I didn't read the transcript as raising this issue specifically. Certainly, your client testified to the fact that he did not understand or believe that his former wife would ever be able to have any access to his retirement, to his pension, which we'll discuss a little bit later on. But I don't recall him raising the point that there was any issue with respect to future alimony, to the contrary, it was apparent to me from reading the transcript that everybody agreed that was not waived.
You're right. Again, Your Honor, it wasn't waived. And just like in McManus, if it's silent, then the court must make a determination if the parties agree.
And did your client ask for that at the trial court, for such a determination? Because I didn't see that in the transcript. Perhaps maybe you could point that out to me.
I will point it out to you, Your Honor, if I can find it quickly, but I would like to say that it was on the burden of the ex-wife, on the appellee.
Okay, all right.
The judge's attention.
You don't have to stop now. The transcript is rather short, so I'll review it again.
Okay, thank you, Your Honor. But because of that, because the agreement was silent, because there was merged waivers, which doesn't make any sense at all, that kind of ambiguity and lack of clarity under McManus says the trial court should have made findings on these points. It's our position that those contradiction of terms and silence as to future alimony requires the court to make the findings. And again, I'll just briefly touch, my client did testify to the fact that he felt this was a full and final settlement. It was argued on that point, and the agreement itself actually says that. But the trial court made no findings about why it was okay to move forward. But let's say we get past that issue, Your Honors. The other hurdle is whether the order at the time of the judgment of divorce was the initial order. Now, my brother, with all due respect, he says in his brief, it doesn't really matter whether or not we say that that was an initial order, but I submit to Your Honors that is a pivotal point in this case. And the reason is because that initial order dating back in 2013 required then that the presumptive durational limits under section 49 were only at most 3.5 years. Those are statutorily imposed durational limits. That would have meant, if you look at the actual real math of that, the expiration or termination of the possibility to extend those durational limits expired on October 9, 2016. That is verbatim in the statute under section 49. Seeking deviation. Well, let me back up one moment.
So you're saying that there's not even a possibility to have sought deviation in this case because of the fact that this complaint was brought after 42 months?
Absolutely, Your Honor. And the authority for that is under section 49F1 and 49F2. Seeking a deviation happens at the initial award, which would have been, in this case, at the time of the divorce. Maybe not other cases, but in this case, at the time of the divorce. It expressly says it in the statute, and I'm pointing here to my statute. It expressly says it in the statute. It says when the court enters an initial alimony judgment, which it was under the Buckley case, that's when deviation from the durational limits can happen. And then on below that, under 49F2, it says that one can seek an extension of the durational limits of an existing alimony order. And I know Your Honors know that review of a statute is a de novo review. So in this statute, it expressly says you can seek an extension of an existing order. Once the order is expired, and in this case, October 9, 2016, you cannot come back after that. And Your Honors, and I know you've read my brief, that's why I go into the legislative intent of the Alimony Reform Act. It's so important, and we know that the Alimony Reform Act was inherently created to give foreseeability and finality to these types of obligations. I would also note, Your Honors, that that's also the point of a final asset division, which, again, as you know from my brief, I'm suggesting that the trial court also overturned a final asset division by being able or by forcing the payor, my client, to dip into the pension in order to then pay what was waived at the divorce.
So let's actually talk about that for a moment, all right? Because your client did testify at the trial that it was his understanding that his former wife had waived any and all past and present and future interest in my pension, quote unquote. Yes. So now let's start with the fact of what it is exactly your client is receiving, which are disability payments.
From the
right?
Correct, yes.
Okay. So how as it is, or how would you describe these disability payments to be the equivalent of his pension? Because they really are coming from two different sources. The disability payments represent 72% of what his salary would be. in contrast to a pension would be what he would have received upon his retirement. And I don't recall now what state troopers receive and from their pension, if it's 80% or 100% of their salary, but.
So Your Honor, with that, and I believe there was testimony that it was the same pension. It's just that he's getting only 72% because he did not work to the retirement age. So it's coming from the same account. And I'm just trying to flip here to the agreement to look for the exact language. Your Honor, if you
really, because would a regular retirement pension be non-taxable?
It is non-taxable, correct. That's
a regular retirement pension. Wouldn't that be considered income?
No, well, I'm not sure. What do you mean for purposes of alimony? Or do you mean for purposes of the IRS?
IRS, in other words, right now, what he receives, his disability payments are non-taxable.
It's not taxable.
Right.
Right.
In contrast, if he was receiving his regular pension, if he had continued working, that would be taxable.
And Your Honor,
in other words, I'm trying to see if the two are different in any way. You seem to be equating the two as if it's the exact same, coming from the same they're the equivalent of one another. Let's put it that way.
Well, I'm not saying that they're necessarily equivalent tax-wise, but because I don't know that answer, Your Honor, so I don't want to. I don't want to suggest something correct tax-wise. But what I am saying is coming from the same account, and in the separation agreement, I'm looking. There's not a page number. But I'm looking at a retirement accounts, and it says wife waives any and all past, present, or future interest in these, meaning the retirement account and deferred compensation account, and husband retains all rights, title, and interest in these and any future acquired accounts and name in his name alone.
So let's talk about that, because what the actual language is that the former wife has waived any interest in a retirement account and deferred comp, another deferred comp, and a separate. So you are saying that in that separation agreement, the term retirement account refers to a future pension.
The pension, correct. And it also says the one state retirement account, and that is the one from which he is receiving the disability income, Your Honor. And I'm sure Your Honors remember, he's also only receiving 72% of it because he wasn't able to work to the age of retirement. So he's actually even receiving less than he had bargained for, technically, unfortunate for him. But then on top of the fact that it was waived by the wife, and now she's receiving some of it. And I would like to point out that in Ludwig, even if the court were to say, hey, there was a previously divided asset, but I'm going to use another one for income purposes or I shouldn't say another one, I'm going to use the same asset for income purposes. Under Ludwig, the trial court must ascertain a portion of the asset that had not been equitably divided already with the wife at the time. And I would submit to Your Honors that did not happen in this case. The trial court did not ascertain any portion of that asset, just as Your Honor may have been suggesting that what can we do with a portion now that may not have been divisible. That was not ascertained, and yes, that was on the burden of the plaintiff.
What about the fact that your client can also earn other money, that he has also employed? I believe the income is from NASCAR.
Sure. So at that time, well, a couple of things, Your Honor. I think that the counter to that is that under VENETUCCI and under the child support guidelines, when a court is looking to attribute income to someone, the court should have also done that for the appellee. The court did nothing of that. The court is required to attribute some sort of income, at least, Your Honor, if they don't attribute it, to consider it under VENETUCCI using the child support formula, the child support guidelines layout there, and that is on page 51 of my brief, Your Honor. But that being said, and I know you've read my brief and you talk about all of her abilities to earn income. And I understand that she's permanently disabled, so is my client. My client does use his faculties to try to earn additional income. There should have been some sort of findings to say that she has the ability to earn. We're talking
there's a stipulation here that she is completely disabled in a manner, in what appears to be far differently and perhaps far more severely than your client. Haven't the parties stipulated to those current health issues?
They didn't stipulate that it was far more severe, and they did not go to.
That's true. Those are my words. But did stipulate to her current condition.
You're right, Your Honor. However, under Hasse, the conclusions must flow rationally from the evidence, and under Floor, the court must examine where there's factual and legal basis for the decision. So there being a line item and a stipulation saying she's permanently disabled, which also applies to my client, doesn't mean that she can't hear, see, she drives, she has a driver's license, she has a car, she goes to court, she does all these things that she could have earned income. But let's go back to your other question, Your Honor. All I was saying was it applies to both people. So you'll see in my brief where I've argued that a first income, right? If someone has a first income, and I'm likening that to his pension, his disability income, might be considered, but you know why I don't think it should be considered in this case. Then you look at his second income that Your Honor is suggesting he earns from NASCAR. Under the case law that I have laid out, that second income should not be looked at. Number one, because his increased hours were only there because of the temporary order that was issued, and he had to afford that. And I see that my time has expired, Your Honors.
I just have a question.
Yes, sir.
I'm a little confused about your argument as to when it was exactly too late
Yes.
to file for an extension beyond the durational restrictions in the presumptive durational restrictions in the statute. Is it too late as soon as that initial order entered without alimony, or are you saying it's too late once the presumptive durational restriction expires?
The latter, Your Honor. So the initial order enters, and in this case, it was in 2013. So immediately the durational limit outside of the court at the time not deviating, which it did not. So immediately, according to the statute, those presumptive durational limits apply. That would have taken you to October 9, 2016. That's when there no longer is an existing alimony award under section 49F2 for, in this case, the appellee to have tried to modify, because it clearly states in the Alimony Reform Act that you can only try to extend those durational limits during that time period, because it says an existing order. I'm going by the verbatim language of the statute, Your Honor. So the initial alimony order enters, that's when you can deviate. There was no deviation. So the statutory durational limits apply. It expired, in this case, October 9, 2016, and she could not come back after that. And I do believe that's also the intent, the entire intent of the Alimony Reform Act, Your Honor.
Okay.
The stipulations were negotiated?
I was not present, Your Honor, so I presume there was some sort of discussion. I have a lot.
Well, your client was represented by counsel at that time, and represented by counsel at the time that he testified at trial.
Yes, Your Honor, yes. But I'm not going to get into it because I don't think it's relevant on appeal. I think there were a lot of problems with that particular stipulation, but we have to work with what we have.
Thank you very much.
Thank you very much, Your Honors.
Attorney Claremont?
Yes, good morning, Your Honors. Joseph Claremont, representing the appellee, Laurie Owens-Clement, the wife in this case. Thank you, first of all, for the opportunity to present in this format. There was some discussion just now regarding the disability of husband. Husband was formerly employed as a state trooper in Massachusetts and suffered a leg injury that caused him to be disabled and start to collect his retirement disability, moved to Florida and became employed down there as a driving instructor. So I think he's allowed to earn up to $40,000 in income other than his disability payments. And he does in fact earn $673 a week as a driving instructor. Counsel began by discussing the issue of the waivers of the past and present alimony and relied on the McManus case for the proposition that because an agreement may be silent as to future alimony, it may be considered ambiguous and the party's intent is therefore a question of fact. I submit that that issue was settled in our particular case because we did file a stipulation that future alimony was not waived and the issues of alimony merged into the divorce agreement. McManus is completely differentiated from our case in that in the McManus case, The judgment indicated separation agreement survived, except for provisions relating to children and medical insurance. Therefore, provisions in McManus relating to alimony survived, were not modifiable. In our case, the provisions relating to alimony merged in the judgment of the court and were in fact alimony. Even if the court were to accept husband's argument that the parties intended to waive future alimony because they didn't include the language "and future" in the waiver provision, I think the plain language of both the separation agreement and the judgment of divorce indicate the alimony provisions merge and therefore modifiable upon a showing of changed circumstances. Also, in the instant case, if we contrast the language in the separation agreement concerning alimony, which is waived past and present, with language waiving the deferred compensation account, which is waived past, present, and future, it's clear when the parties intended to waive future alimony, they specifically stated in the agreement future alimony was waived. And then finally, on that issue, even if the parties' separation agreement contained language indicating future alimony was waived, which it did not, and the provision waiving the future alimony survived, which it did not, the trial court would still have the authority to grant alimony to the wife if the judge found that countervailing equities existed pursuant to the Stanzel case. Specifically, the court noted in Stanzel, they can refuse specific performance of a surviving alimony provision if the spouse seeking modification will become a public charge. In fact, in our case, wife is totally disabled due to severe and ongoing medical issues, which was stipulated by the parties. Her income was limited to $45 a week in food stamps, and she did receive assistance from an 85-year-old benefactor who helped her with the rent we had met through the food bank. But so absent the alimony awarded by the trial court, wife is on food stamps and has no ability to earn further income, will in all likelihood become a public charge. The second point dealt a bit with the initial presumptive durational limits and whether we can seek deviation, and counsel seemed to indicate that the deviation must be at the time of divorce, which wouldn't make sense in our case because the deviation is based upon the interest of justice. We have a wife who became—
I understand her argument to be, even before you get to the issue of interest of justice, is that that the time period in which your client could have filed a complaint has expired. Her point is that the durational limits of, I'm going to say 42 months or so, 42 months began at the time that the judgment entered. And since this complaint was brought after the 42-month period had passed, that therefore there's a cutoff and that your client is prevented from moving forward.
I don't believe that's the case, and in fact, it wouldn't make sense. If the deviation has to be filed at the time of divorce, you would have to be aware of the change in circumstances that would be coming forward at some point in the future that would cause the deviation to come into play. So in this case, the deviation occurred, the change in circumstances occurred when the wife became totally disabled. And at that point, I believe she was well within her rights to file a complaint for modification. In addition, there was some discussion as to whether the alimony could extend beyond husband's future retirement age. And although the Alimony Reform Act generally terminates alimony on full retirement age, it may set a different alimony termination date for good cause shown. So the wife argues that whether it's
can I just stop you for a sec? What if the health issues that your client faced didn't happen 3 years after the divorce, but happened 20 years after the divorce? Is there any time restriction there, or could the judge just say, well, the client is now 80 something, has dementia. I find in the interest of justice that her ex-husband from a 71-month marriage needs to pay?
Well, two things on that. I believe that it's within the court's discretion, the judge's discretion, to determine what in fact is good cause shown as the criteria, if an extension of an existing order. In addition, the wife has to prove by clear and convincing evidence good cause shown through a material change in circumstances. I believe in your scenario, Your Honor, if you're talking about 20 years down the road, there might be a change in circumstances on both parties. So the court, I believe, would have the opportunity to review not only whether there's good cause shown, but whether in fact there was a material change in circumstances on both sides that would at that point allow for an award of alimony. It's certainly not a given, but in this case, it happened a few years after they got divorced. I can see that if it happened 30 years after they got divorced, that the material change in circumstances might be different. But in this case, it wasn't, so I believe that.
Why isn't your sister correct that, putting aside the specific provisions of the Alimony Reform Act, that the overall thrust of the act is to give more certainty and to resolve things, put an end to closure, if you will?
Well, the durational limits, Your Honor, are called presumptive durational limits. They're presumptive because this is what the presumption is based upon the average case or the normal case that may come along. When a situation occurs, such as in this case, that would deviate from those, that's what gives the opportunity for someone to seek the alimony because of the good cause shown. So I think, even though it says, yes, we would like some certainty at the time of divorce that alimony is going to be within these durational limits, the statute is set up in such a way that it's presumptive. And you can rebut that presumption by showing the good cause shown, which I believe certainly in this case we've shown because of her severe and ongoing medical issues.
So the direct answer to Judge Milkey's question with respect, if it happened 20 years later, is you say yes, that finality would be put aside, and Mr. Clement would be subject to cost and expense of having to go in and defend a modification some 20, 25 years down the road.
I believe it is possible, even under that scenario, for a court to be able to examine all of the circumstances to determine if the change in circumstances warrants that, that award of alimony.
How can that be fundamentally fair?
It's the rebutting of the presumption. We take each case as we find it. In this case, the change in circumstances happened relatively quickly after they were married. If it was 20 years later, maybe a court may determine that that is not good cause shown and that there is not a sufficient information or evidence to be able to modify it. But I think that would be up to the court to determine at that time. It's not a hard and fast durational limit. They gave the courts the discretion and the authority to move away from that to prevent someone from becoming a public charge, as in this case. In addition, counsel spoke a little bit about whether the award of alimony in this case is double dipping because the wife waived rights to the retirement accounts, the deferred compensation accounts.
Let me ask you, when you look at the separation agreement and the language there of the I think it's paragraph 3, if I'm not mistaken. Yes. What do you say that she's waiving when you talk about when the agreement refers to, quote, husband has one state retirement account and one deferred compensation account with Great West?
At the time the parties were divorced, those particular accounts were valued and placed on the financial statement. I forget exactly what the amounts were, but they were stated on the financial statement, and wife was waiving her rights to those accounts as a division of the asset. So there would be no quadro or any other sort of division of those retirement assets. But I submit in this particular case, the wife didn't seek a portion of her husband's pension as a division of assets, as she had waived her rights in those assets. Husband's disability payments were not even on the parties' radar when they got divorced, but wife did seek and was awarded alimony based upon the stream of income received by husband from his disability retirement payments and his current employment. And in the Andrews case, the court upheld the decision of the probate court judge to treat a husband's military pension as a stream of income, as opposed to an asset to be divided. In our case,
I'm sorry, just so I could be clear, are you saying then that your client did waive any right into her former husband's retirement pension, the actual pension that he would have received had he been able to continue his employment and then retire?
yes, I believe the actual pension account. In this particular case, husband received a disability retirement.
No, I understand that. When you say that, that's different as far as you're concerned.
It's different, exactly. So he's getting 72% of his former income, tax-free, and those are clearly separate, I believe, from the party's asset division. So I believe that it's not double dipping where we can identify sort of.
If we were to determine that the disability payments were the equivalent of his retirement pension, then you would have to agree, wouldn't you, that that the wife had waived any right to that?
In that case, I would, but we're not talking about a fund of money that's subject to division. We're talking about a stream of income at 72% that lasts for as long as the recipient lives. So this is not a fund that would expire if we were to take money out of it. It's a stream of disability income.
But neither would a retirement pension. A retirement pension would have lasted until the individual.
Depending on what was put into the account and what the value of the account was at the time.
Well, we know this. I mean, we also know what his employment was, and so that's ascertainable, right?
Right, exactly. So I believe it can be differentiated in that way. We're talking about a stream of income as opposed to an asset. Also, counsel raised the issue as to whether husband's income from a job obtained after the initial award is appropriate. I believe in this case, husband was disabled as a result of a leg injury. He began receiving his disability retirement payments after the parties were divorced. And as we spoke, he receives $1173 in those retirement payments, equal to 72% of his former pay tax-free, but also receives income from one job. He's a part-time driving instructor for which he receives $673 a week. I believe that the child support guidelines properly considers both incomes according to the guidelines defined as income from any source. So we have the income from the disability payments. We also have the income from the one job, not the second job. And I believe that both of those can be considered in terms of awarding of alimony. And in fact, I believe in this case, the judge looked more towards the need of the wife and not just his income. Because if we use just his income and we calculated alimony based upon that, the alimony order could have been in the nature of $400 to $500 per week. She based it upon what the need of the wife was and limited the alimony to $200 per week, which I think was appropriate in this case. So,
Counsel, can I ask you about the wife's losing her SSDI as a result of the husband's paying alimony? Isn't there something inherently unfair about that in terms of, who's going to be the ultimate insurer, if you will? If we as a society, have designated the SSDI as the safety net, and the court says, no, the husband's going to pay it. I realize it's not the same amount, but it was a sizable chunk of the alimony.
In fact, Your Honor, I think there was some confusion. The income that she did receive was an SSDI. It was SSI based upon her disability. So she received 2 months of SSI at the rate of $490 per month. And that is also need-based. When the temporary alimony began at the rate of $200 per week, her SSI terminated because she was receiving that other income, which exceeded the amount that that SSI would pay. So SSI terminated after only 2 months. She only received 2 payments of $490 a month.
But why isn't that problematic, that the net effect of all this is that the husband is paying what SSI would have paid and more so.
He is paying more. SSI would have paid $490 if there was no alimony. He's paying $860 per month, according to the alimony calculations.
Okay. I see your time is up. Justice Milkey, Justice Desmond, any further questions from the panel?
Not here.
No, okay. Thank you both very much. Stay safe and help.
All right, we are live.
Okay, good morning, everyone. I think it's still morning. What time is it? Oh, just about noon. So just got in under the turn of the hour. Thank you for participating in oral argument today via Zoom. We recognize that it's a challenge to use this platform. We may have some technological difficulties. We will have patience with you, and we ask that you have some patience with us as well. Before I introduce the panel, on behalf of all of us, I just want to say that I hope that you're all well, that your families are well, and that you're weathering the pandemic in a manner as best as you possibly can. Second, I would also like to thank the members of the appeals court who have developed and implemented this platform, because it permits us to get our work done and to forge ahead with cases that are important, such as this one. And finally, I just want to remind you that we will be conducting this argument as if we were in the courtroom. In other words, you, Ms. Nair, represent the mother, and so you have 15 minutes. On the other side, I understand you're both splitting your time 7.5 minutes each. There is no rebuttal. You can be assured that we have read the entire record and that we're ready to hear your argument. And I want to remind you that this case, of course, is impounded. And so it's important that nobody use anyone's real names, okay? Because we are live. This is our way of keeping the courtroom open to the public. And so this is being streamed to the public. And so therefore it's important that we follow the impoundment order. Okay, next, that said, I'd like to introduce the panel, Justice James Milkey and Justice Kenneth Desmond. My name is Ariane Vuono, and I'll call the case officially. It's the Department of Children and Families versus Mother and Another. The number is 2019-1298. Ms. Fisher Nair, am I pronouncing your name correctly?
Absolutely, Your Honor.
Okay. Look forward to your argument.
Thank you. May I begin?
Yes, you may.
Good morning, good afternoon. May it please the court, my name is Julia Fisher Nair. I represent the appellant mother in this matter. Today, the mother asks this court to vacate the orders of the trial court, finding that the Department of Children's adoption plan was in the best interest of the child. We're asking—
Can I ask you a question from the outset, please?
Absolutely.
Given the issue is best interest of the child, what, if any, consideration is permissible for our court now to consider with respect to the daughter who passed while in the adoptive family home?
At this point, this matter is only about the child who is still part of the appeal. There were 2 children initially, and as you correctly pointed out, one of the children unfortunately passed away during actually the pendency of the appeal.
And my understanding, as limited as it is, was that was due to a fall that was suffered. And my question is all of that outside our analysis and best interest of this child?
Well, according to the law, it is. The trial court did mention the fact that this child passed away when it issued its findings of fact and conclusions of law in August 2019. Mm-hmm. However, no other details were provided, and it is outside of the record as far as this court is concerned.
There was no effort below to expand the record after the death of the child, correct?
I believe that there was some discussion. However, the record was not expanded as to this child specifically.
So in view of the appellate principles about confining ourselves to the record, we have to put blinders on and not consider the fact that there's been a major change of circumstances?
Unfortunately so. However, there is still enough, as my brief has pointed out, to determine and to discuss what was done for the other child who is still alive, and what was not done for this child, and that it wasn't in his best interest for the decision to be ultimately what it was by the trial court. And that is why I am here today on behalf of my client. So even though there was a child who passed away, and absolutely the mother would love for this court to determine this as part of this appeal, unfortunately, it cannot be.
Yeah, but I mean, there are circumstances in which, for example, when an appeal may become moot, as it has become moot, for example, with regard to the daughter, where we can ask questions outside of the record. With that in mind, let me just ask a very limited question, which is the pre-adoptive family to whom the children were supposed to be adopted, are they still in the picture as the designated adoption resource?
No, they're not, Your Honor, they're not. The pre-adoptive family, for the child who remains part of this appeal, in fact, he was no longer with that pre-adoptive family.
No, I understand the child was removed, but I mean, wouldn't there have to be some supplemental proceedings in the trial court in terms of what happens next?
I believe so. However, the children were, the plan was determined to be adoption. So actually, this is actually the material change in circumstances that you're referring to is the reason also why we're asking for this to be remanded back to court, so that where in trial court is the best platform to make a determination based on the material change in circumstances, and that decision needs to be looked at again, essentially, and considering the errors that were done during the court's issuance of findings, and considering everything that has taken place. Yes.
But you're actually asking us to evaluate the trial judge's decision at the time of trial. In other words, whether or not there was an abuse of discretion in determining that the plan proposed by DCF was in the best interest of the child, instead of the plan proposed by the mother, which would have been to place the children with her mother, the maternal grandmother, right?
Yes.
Okay, so back to the questions that both Justice Desmond and Justice Milkey are asking. We can do that. We have the record before us. We can look to see whether or not there was an abuse of discretion or not at that point in time. But to what end, if there's been clearly some significant changes?
Well, so the appeal, the brief as we have filed is not based on the first child's death. It is really based on review of the record at the time of trial and the court's findings subsequent to the trial, and mother's motion to reopen the evidence, and the court's allowance of the last exhibit in, and the argument that in fact there was an abuse of discretion based on that, and the court did commit an error. So we are not asking this court to go outside of the record. That was not part of the argument. We are asking that we are arguing that actually the court did abuse its discretion So that's the basis of the argument the mother is making in this case. As to the
So what if, excuse me, go ahead.
I understand that. So the order required that the child be returned to DCF. That's correct? That's the current status?
The order, well, DCF already
By
had
Judge
custody.
Spinelli.
Yes.
And are they now seeking a new adoptive family?
I'll be honest with you, I am not aware of what DCF is doing at this time as to this child.
Given this present posture, can the grandmother now reapply for a kinship placement?
No, Your Honor, because currently this child is on the permanency plan is adoption. So DCF has made it very clear during the trial that they're not considering the maternal grandmother. And that was part of the reason that the maternal grandmother was seeking to be, she was the competing plan that the mother presented during trial. That was the time to come forth and present the maternal grandmother. Once the trial court made its decision in choosing DCF's plan as the proper adoption plan and the best interest of the child in trial court's opinion in any case, that sort of ended the maternal grandmother's recourse as far as what could happen in trial court. The only recourse that she now has was for the mother to file her appeal, which is what she did.
Thank you.
Okay. Anything else that you would like to address?
Yes, I just want to reiterate that there were several errors done in this case. The court did not engage in an even-handed assessment of the evidence. The court's discretion is not unlimited. The court was obligated to consider all of the relevant evidence, and it is absolutely the court's own findings show that the court considered everything regarding maternal grandmother's criminal history to be relevant. So taking that into consideration, anything to do with the maternal grandmother's criminal history should have been looked at. And when the court did not correctly state that there was an exhibit admitted into evidence in July of 2018, only 3 weeks before the court's decision, exhibit number 70 that in fact showed that maternal grandmother's open criminal matter was actually closed and dismissed at the district court level. And subsequently, the court consistently mentioned incorrectly that she still had an open criminal matter and ignored that there were 70 exhibits in evidence when it kept saying that there were only 69 and did not even mention that there was exhibit number 70, and also stated that there were no motions to reopen the evidence filed by anyone, when in fact the court allowed the motion to reopen and admitted that exhibit into evidence.
But the court's decision didn't really rest on that open matter, which was a motor vehicle matter to begin with, I believe. So the fact that it was dismissed doesn't seem to have played a big role in the court's analysis regarding her cumulative record to that date. So
well,
what's the prejudice?
So the prejudice is that the court reiterated the fact that the maternal grandmother had an open criminal matter, regardless of the fact whether it was related to a motor vehicle incident or not. It was clearly important to the court. Findings 222, 232, 240, 243, conclusions of law 37, 38 at minimum is where the court mentions that. So the court found it important and specifically highlighted she had an open criminal matter. So that's the reason we believe that there was no even-handed approach.
What specific relief are you asking for at this point? Because I mean, if the judge was choosing between two plans and one of the plans was seriously affected by intervening events, wouldn't this have to go back anyway for at least some supplemental process? And you know, I don't think you're asking us, are you, for us to just order the child be placed with the maternal grandmother?
We are asking that this matter be remanded back to trial court, and at that level, the court engage in a de novo, essentially hearing on the best interest of the child remaining.
But just with regard to the plans, or are you trying to work fitness back into this?
No, just regarding to the plans, because the mother actually stipulated to unfitness.
Right.
So she gave up her right to appeal that. And she is seeking, however, that the trial court reconsider the best interest analysis as part of her relief.
Okay.
And I also would like to highlight, if I may, that the other issue that the mother believes there was some prejudice on in trial court's analysis of the evidence is that the court reprimanded, and this is a public policy argument, the court reprimanded the maternal grandmother in its findings for her reliance on public resources. The court highlighted repeatedly that the maternal grandmother has always resided in public housing, that she has not had a private apartment ever in her life. The fact was the maternal grandmother never had any eviction matters against her. She testified that she paid her utilities. And in contrast, the court praised the foster care parents, the potential pre-adoptive parents, in their thoroughness and sort of preparation for the subject children to be placed with them without really admitting to the fact that the reason that they had all of these opportunities available to them was because they were supported by the state and by DCF and had all of the information about these children available to them, essentially.
You say in contrast, but isn't that comparing apples to oranges? In one breath, you seem to be pointing to the financial wherewithal of both plans. And then in the other argument, you seem to suggest that the pre-adoptive family had more support from DCF and was provided more information so that they could make a better case for their plan than was afforded the grandmother.
Well, it's not comparing apples to oranges, if I may. The trial court did not expand on this principle, meaning if the maternal grandmother had the same resources and support available to her, she would have been prepared as well. But the court kept essentially criticizing her and making, in my opinion, negative comments about her reliance on public housing, while under the same breath, sort of praising this foster family who was receiving financial resources from the state. But the court never mentions that. The court does not acknowledge the fact that this placement, this family was receiving all of these resources, yet is saying the maternal grandmother is relying, and she's never had a private apartment. That should not have been, this should not have been part of the argument. It's very.
I think we see your point on that. I'm just going to point out that your time did expire a little while ago, but I want to be sure that Justice Desmond feels he had an answer to his question.
Thank you.
Okay, all right. Justice Milkey, do you have any further questions? No? Okay.
Thank you very much.
Thank you very much. Thank you for your argument. Okay, so we'll return now. Let's see. We'll go to Attorney Parker or Attorney Bayless?
Attorney Bayless, please.
Attorney Bayless. Okay, thank you.
May it please the court, Jeremy Bayless for the Department of Children and Families. I'd like to begin by saying that obviously the death of the daughter was unquestionably tragic, but that change in circumstance does not require any reevaluation of the adoption plan, as the plan approved by Judge Spinelli included both adoption by the pre-adoptive family and, in the event that that was not possible, recruitment of an appropriate adoptive resource. That's written explicitly in his order adopting the plan. And well, I'm loath to go outside of the record, as almost nothing about the circumstances of the daughter has been put into the record that's before the court now. That recruitment process is being done. My sister may have more information with the specifics of the current status, but the plan was not solely this pre-adoptive family such that there would be a need for a remand to find out what happens next. Judge Spinelli already considered and compared the maternal grandmother versus the potentiality of needing to recruit a pre-adoptive resource for the boy, and found that recruitment was a better plan. And he did so because there was ample evidence in this record that the maternal grandmother and placement with her would not be in the children's best interest. The maternal grandmother had a lengthy criminal record, over 127 charges, including assault and battery with a dangerous weapon, assault and battery, destruction of property, operating under the influence.
Does it matter that several of those were 20, 25 years ago, and several of them were dismissed?
It is certainly something that the court would have considered. The court viewed the number of arraignments and the length of time during which they were accumulated as evidence of sort of a pattern of behavior on the maternal grandmother's part. So certainly a 30-year-old charge on its own would not likely be enough, barring some exceptional circumstances. But when those charges are happening multiple times a year for 30 years, that paints a very different picture, especially.
And that was the point he was trying to convey when pointing to, at the time of trial, she still had an open matter.
Yes, and it is certainly unfortunate that the court allowed the admission of an exhibit and made no explicit finding about it. However, that doesn't constitute reversible error. Barring any extreme charges in her timeline of criminal involvement, there's no one charge that makes or breaks the court's point. When that point was, the maternal grandmother continuously becomes involved with the law. The driving violations may have been dismissed, but there's still multiple police responses for domestic violence over the 5 years leading up to the trial. There's still the maternal grandmother's dishonesty with the department and attempts to conceal that criminal record, informing them that her only issues with the law were traffic violations. A similar fact is true of the maternal grandmother's involvement with the Department of Children and Families. A 28-year-old supported report of abuse or neglect on its own would have to be very, very bad for that to be particularly relevant to her fitness now. But, and I'm sorry, not her fitness now, whether or not placement with her would be in the children's best interest now. However, the fact that, similarly to her criminal record, the maternal grandmother misrepresented that departmental history and said that she had had no involvement with it at all, is a factor that the court properly considered, especially when the judge was being asked to compare the maternal grandmother with her issues with this pre-adoptive family who, on paper and in actuality, apart from the tragic circumstances, is an impeccable pre-adoptive option. They were engaged with the children. They were helping them with their schooling independently of what the department was asking. They were taking those actions on their own. The pre-adoptive father was available to be a male role model for the boy, which the adoption worker testified was an important, would be of great benefit for him in his development.
But isn't that part of the problem, is that we're dealing with now, which is namely the judge was swayed in part, arguably, by, you know, this seemingly dream pre-adoptive family that is now no longer in the picture. I'm looking at the decrees in front of me. Where specifically is it that the judge addresses the possibility of this falling through and having to move to recruitment?
Unfortunately, I don't have it sitting in front of me. I can see the page though. It is one of the decrees. It is the last paragraph above the signature block. It's the line in which he approves the adoption plan, and recruitment is mentioned in there. And if we're having trouble locating,
is this before or after the child died?
This would have been, I guess the decrees would have entered before. The findings were after. And if it would be helpful, I can also submit a letter to the court with the explicit citation that I'm referring to. I just unfortunately did not include it in the notes I have and can't tab out of the window to find it. But the plan included recruitment. And if there were an instance, had this been a case where both plans seemed okay, that happens frequently in these cases where the court is simply picking between two viable options, which one would be best. We might be in a very different position. However, in this case, the court affirmatively looked at the maternal grandmother and found that she was not a good option for the children. It wasn't simply that the foster family was better, although that was the minimum, that was all that was needed for the court to exercise its discretion and approve the plan. But there was ample evidence that the maternal grandmother was not a safe caretaker. And that was what factored in. There was evidence before the court, as the court found, that the maternal grandmother had come to pick up the children appearing under the influence of alcohol. There was evidence that while mother was living with the maternal grandmother, the children were being medically neglected. The daughter was hospitalized for failure to gain weight. And while she was in the mother's care at that time, she was living with the maternal grandmother, who had clearly taken no action to ensure that that happened. And then finally, the maternal grandmother made no effort to prepare for the children to live with her. While she was not receiving information from the department about their medical appointments, she was the children's grandmother working with the children's mother. The fact that she didn't seek that information out on her own is not positive evidence for her case as the plan. I see my time has elapsed, so if there are no further questions, I will rest on my brief.
Seeing none, thank you very much.
Thank you.
Attorney Parker.
Good afternoon, Your Honors. In answer to one of the questions, the recruitment of an appropriate home is mentioned in the findings in the addendum at page 133. That's where the judge says the plan is the M family or recruitment in the event the M family doesn't work out. Addendum 133.
We're on 133.
I don't have the addendum in front of me, but it's in the findings. It's in the findings. The lack of resources by the maternal grandmother was not the grandmother's problem. The standard is that the findings should not be outside the bounds of reasonable alternatives. The rejecting the grandmother was not outside the bounds of reasonable alternatives, given her long criminal history, which included incarcerations multiple times, domestic violence brought against her, The mother reporting in the assessment that there was domestic violence between the maternal grandmother and the maternal grandfather when she was growing up, and the failure to disclose her DCF history were among many, many factors that indicated that the grandmother needed to be rejected no matter who the adoptive placement was. I am aware of what happened, if I can go outside the record, if I have the court's permission to do so. Can I say where the child is?
Where the
Now?
the child, the older child, the child that is.
The child that this case is about. I know where he's placed and what his current status is.
What, has there been a recruitment as the judge had anticipated? Was there
Not
recruitment?
only has there been a recruitment, he is going to be adopted, if the court affirms, by a foster family that one of the many foster families he lived with. He's the only child in the two-parent family. And I'm going to say that the child wants to stay there very much. He has his own room. He has all of his educational and medical needs are being met, and he's very happy. So that's where he is. It's in the child's best interest to have a stable family. And the maternal grandmother never, despite knowing what was going on with the mother, never assured that the children were getting their needs met. When the child was an infant, the mother lived with the maternal grandmother. And during that time, despite his being born positive for cocaine, the child received inconsistent medical care and was often behind on his well visits and immunizations. When the child was 2 years old, he was still living basically with his mother, with the grandmother. His 9-year-old brother was screened in for allegations of sexual abuse. And the reporter also stated that both the grandmother and her friend had significant drug and alcohol problems.
But the grandmother wasn't the primary caregiver at that
They
time,
were
or
living-
custodian.
That's true, but they were living with her. And that's, she could have taken steps because they were in her household to make sure that the children's needs were being met. The grandmother did little to provide stability during any of the children's childhoods, despite the mother's many shortcomings, substance abuse, mental health issues, turbulent relationship with the father. And the court found that the mother and the grandmother were not honest about with the department about issues important to the safety of the children. They were not honest, for example, about the grandmother having a DCF history where she left children unsupervised for 6 hours. They were not honest about her criminal record. Neither the mother or the maternal grandmother asked for reconsideration of the many denials, the two denials of the grandmother being foster mother. They kept trying to qualify her. The department kept looking at her because they always look at family first. And they kept rejecting her, and there was an area clinical review team who concluded that the grandmother's criminal history, and including incarcerations multiple times, precluded her from being a foster mother.
Didn't the grandmother present herself as a kinship placement on her own?
Only on one occasion, and that was looked into and denied because of the criminal record by the department. And this area review clinic team concluded that it was, the social workers were right, the original social worker was correct. The history, not only of the history of the criminal record, but the grandmother having not formally disclosed the DCF history, which then came out, and some things that were learned during the assessment, like the mother saying that there was domestic violence during her childhood. they determined that the grandmother couldn't be the foster placement. And it's this finding by the department multiple times that she couldn't be the foster placement that precludes her from being the adoptive placement. If she had been the foster placement, she would have been the adoptive placement. That's what always happens with grandmothers. So there were ongoing incidents of domestic violence with the grandmother, and she failed to meet the educational needs of an older sibling when she did have that older sibling living with her. Despite his having to repeat the D child, having to repeat kindergarten, she failed to go to the meetings at the school or answer the phone calls from the school. So she was found not to have the necessary skills to be the adoptive placement. And there was ample evidence of this long history of severe shortcomings by the grandmother. She didn't even go to visits that she was invited to with the child. The social worker Danielle testified that she did not place any limitation on the grandmother's attending visits. That's in the transcript, volume 4 at page 61. From the time that Danielle became the ongoing social worker on September 29, 2017, to the date of her testimony on May 15, 2018, maternal grandmother had only attended just a handful of times. And that's in the transcript, volume 4 at pages 58 through 60.
Attorney Parker, I want to let you know that your time has expired. Was there anything in particular that you wanted to tell us before?
Right. Under the case law, the grandmother, this appeal is not properly before the court because while the placement was vacated, the termination was not vacated, and that was docketed. And what docketing triggers that you don't have a right to appeal. The mother lost her right to appeal when that termination of her rights were docketed, and that is on page 6 of the findings dated August 2nd, 2019. The judge states clearly discussed and agreed that all parties that the only issue to be heard was the best interest of the placement.
Okay, all right. Thank you very much. Thank all three of you very much. We appreciate your arguments. These cases are always very difficult. We'll take it under advisement. In the meanwhile, between now and the time you hear from us and afterwards as well, be safe, be healthy, and we wish you all the best during this difficult time. Okay.
Thank you very much.
Okay. Thank you. Bye now.